হ্যাঁ, আচ্ছা স্যার বলুন স্যার। হ্যাঁ বলুন প্লিজ। চলো, আবার অলরেডি লগ ইন।
Good morning, my lord. I filed this memorandum of appeal. It is going to address. I crave leave for filing this with a website copy. I have already paid for certified copy.
When the order was passed? When the order was
Order was
passed?
passed on 30th January and 5th February, impugned orders. My child is out of class. He's not being allowed to enter into the class, enter into the school either.
May I pay for
Annex the server copy and also the application for certified copy. Yes, server copy.
may I pay for leave to file this mandamus appeal without certified copy? My lord, the order was passed on 20th January. I applied for 21st. This is the application.
Annex kora আছে।
Yes.
ভেতরে পেছনে
And
আছে।
move this
Annex it first.
Yes, I shall.
Please, first you do it, then give.
My lord, may I permit to obtain leave
My lord,
to
what I
file
am-
an appeal without certified copy?
Where is the presentation form? Where is the gentleman? Where is the presentation form?
My lord,
My lord, may I permit? My lord, may I permit to file an appeal without certified copy
Order was passed on.
on 24th January 2025?
Have you applied?
Yes,
Have you annexed the copy?
my lord, kindly is my
Do
office. My lord,
annex.
kindly leave granted in the meantime. My lord,
No.
my lord, may I?
Bad bench.
Before
First
that,
you annex. No.
My lord,
Server copy. Annex, then give.
my lord, move this application on urgent basis. Urgency is there.
That is first you go and file, then we'll see.
Yes.
Lord, I am praying for listing the matter. Honorable Court directed the matter appear after 2 weeks. The matter taken up on 16 January. The matter is not listed. Therefore, I am praying for listing the matter.
My lord, once again, I am trying my luck, my lord. Item number 171 onwards, the primary appeals, which are pending before your lordship. Later date be fixed for on the to be mentioned.
We'll fix a date. Now we have cleared off mostly all the
The petition, the
the
respondent,
judgments. Now we
respondent,
just wait for some time. Don't
Lordship, may I be permitted for inclusion of one application?
application give.
Well, may I be permitted to mention one bill in connection with appeal?
Bail?
It is running in the list.
Bail?
Bill, it's,
Why bail?
well, it's running in the list as 252 number item. Kindly fix a date, madam.
Bail applications we don't have.
Assigned matter, madam.
Assigned matter bail.
Yes, madam. CRA
Yes.
336, 2007.
Bail in connection with appeal.
Yes,
The
madam.
appeal has been assigned.
252 number item. Gobindo Shaha.
জানি না আমি তো আশ্চর্য
Lordship, may I permitted to mention
Yes,
one application?
criminal appeal.
And you fix a date, my lord. Petition is in custody for 18 years, my lord.
এটা কোন ম্যাটারে যেটা শুনানি হয়েছিল ঠিক আছে একটা অ্যাপ্লিকেশনে দিয়ে দাও অ্যাপ্লিকেশনে দিয়ে দাও ইয়েস What? No, they can now assign to this bench or decided over by me or আমি দিয়ে করেছি যদি decided over হলে তখন দিয়ে দাও না হলে
My lord, may I permit to mention one matter? Determination of Honorable Justice Prabhat Chakra.
what?
Your lordship has given determination.
Whether was a part of that bench?
His lordship, I mentioned there, that was the item number 1 of the Friday's list. This bench will not sit, your lordship's determination is there, day after tomorrow, date fixed for lower court.
What is the urgency?
Urgent, refusal of injunction order, they want to pass this order, therefore, I filed this here.
No, wait for the regular bench.
Day after tomorrow, date is fixed for lower court. He will, if he passed an order, my petition will be totally infactuous.
What is the lower court?
This is the tribunal of the Land Reforms Tribunal Act.
The lower court.
Lower court means such a DLRO has date.
So lower court.
DLRO is the
Lower court.
but he is the quasi judicial power.
So the court.
Therefore, I have told him. Let it appear tomorrow.
You mentioned tomorrow.
আমি দিয়ে দিচ্ছি শুক্রবার 1 নম্বর ছিল আমি দিয়ে দিচ্ছি এটা আমি
for inclusion.
শুক্রবারের লিস্টের এক নম্বর।
Chartered accountant.
হ্যাঁ।
Your Lordship may be permitted to mention one matter. Your Lordship, it's an application under Group 2, under the heading for appropriate orders.
Or appropriate.
Your Lordship, it's
Application.
one is for condonation of delay, and then
Yes, call the list.
Original site, review applications, item number 1, Srimati Charushila Trust Estate.
much for the respondent.
এই হবে। ও আজকের জন্য আজকের মধ্যে
Yes, council change হয়ে গেল।
So point of
What is this?
আগের দিন জোসেফ
Where is the application for review?
Yes, may it please your lordship, I am appearing for the appellant. We are taking a point of maintainability.
Just 1 minute. Did you obtain the leave to file a review application? Of the court appointing you a receiver?
No.
Yes, on that day, my lord had taken
there
this
is this
point, now
question.
the council is changed, my lord.
Receiver was himself arguing, my lord raised a point that how can receiver argue without the leave? Now, my lord, Mr. Bhattacharya has been appointed. My lord, we
No,
take
he
a
was
also, my
very
lord,
much
point
there,
of, he was also there last day. We take a point of maintainability that, my lord, no, there is no resolution from the trust directing.
No, it's not a resolution from the trust. It is
Or
a
may lord,
question
any
of permission from the court.
permission from the court
Permission from the
to
court.
appoint some advocate. Or may lord, to represent the
No,
trust.
But the last order, my lord, had been
initiate
to
a
record.
proceedings.
Yes.
That has to be done.
Yes,
My lord, on that score, the matter ended last day.
Yes.
my lord's last order also.
May I place, I would beseech to kindly take up my stay application made in connection with the review application so that I may
Stay
place
application, where is the stay? Where is the review application?
review application, that is also
A
appeal.
review. I do not find a review application is here.
This is here, this application is here.
No, this is, you are talking about GA1.
Yes.
GA1 is a stay application. Where is
Yes,
the
sir.
review application? I know it. I know it. Where is the review
Memorandum of review has been filed.
I am asking you, where is the review application?
This is the only,
The memorandum,
yes.
where is the application for review? Have you seen order 47? Look at order 47. Do you have the copy?
No.
Look at order 47, rule 1.
Person considering himself aggrieved. New important matter of evidence which after the existing does not recognize. Mistake.
May apply for review.
Yes, may apply for the review. Rule 3, a party is not appealing from a decree or order may apply for review judgment not stand pendency of except on the grounds such a the decision in question. Application.
It talks about the application for review. Where is an application? It has to be supported by an affidavit.
As far as
I
I
have to, like a revisional application, you'll have to make a grounds within that application.
on the
Where is the affidavit in the memorandum? Where is the affidavit?
page 14,
Nothing. Just like a memorandum.
Yes,
of appeal.
memorandum, there's no,
Where is the application for review? You have to wait for the review of the order. Your application is only stay.
yes, my lord. My lord, but not
So
as,
it is an application in the review. But where is the review application?
my lord, I haven't, honestly speaking, I haven't filed a review applications.
So
Only memorandum of
is
review has been,
not competent then.
memorandum of review has been filed, my lord.
Is it the proper way of filing a review? You are represented by a counsel. Mr. Gupta, either you release him, you want to argue, come and argue.
এই আজকে বলবে না for the trust না trust
One discovery of new important documents. We shall make it as a my lord, may I submit one thing, my lord? As per order 47, rule 3, my
Rule
lord.
1 and rule 3, both have to be read together.
Yes.
Please read conjointly and tell me what you perceived from there.
Lord, as far as I understand, my lord, memorandum of review should be filed for the,
It says mutatis
Mutandis,
mutandis. It does
with-
not say that it will be filed like a appeal
yeah,
under order 41 rule 1. No.
obliged to lordship, exactly.
No. It never talks about it. It says mutatis mutandis.
With necessary
What is
changes.
there is that this, like a revisional application, you'll have to state the facts of the review and the grounds of review to be incorporated as we do in a revisional application. Along with the memorandum, that will be a separate one.
My lord, I would humbly submit, my lord, if your lordships insist on filing applications, my lord,
I
kindly grieve.
don't insist. That's the
No,
law
my lord,
which
kindly
insists.
grant us leave, my lord, we shall come up with
We,
applications.
we don't insist
No,
anything.
no, my lord, I don't want to,
Grant the,
Lord, I
we
don't want
say
to break the
according to
law. My lord, I don't want to break the law, my lord. Lord, if,
One permission, as a receiver, to assist your lordship.
as a receiver who is
Receiver is an appellant before us. So I think the receiver, if he's not a party, I can.
Receiver is not the appellant.
he has his counsel
We will say so. We are passing an order to.
my lord, I would like to come up with applications, my lord, in that event, my lord.
My lord, lordship will kindly
have their avenue.
if the application was not in form, the department would not have accepted the review, my lord.
So the law is to be determined by the department,
No, my lord.
and the law has no manner of application for the bench to consider.
My lord. My lord,
Is a very interesting argument which a responsible member of the bar is making, that it is the department who will consider what is the law, and bench has nothing to do with this regard.
My lord, I would like to,
They have accepted.
না এখন now
my lord, I would like to come up with applications, my
my
lord.
lord, I will check the law tomorrow.
No.
Give it tomorrow.
No, no, application করে দেবো, no, no. We'd like to file application. No, no, please don't.
Check the law.
No, my lord, I would like to come up with application. My lord, I,
We'll check the law, my lord.
সে ব্যাংক অ্যাকাউন্ট অপারেশন স্টপ করে দিয়েছে
The lordship will give you one.
মানে receiver of a religious trust
my lord, I would like to come up with applications, my
On
lord.
this point, my lord, instead of lordship passing the order today, my lord, keep it tomorrow, my lord.
স্যার আপনার কাউন্সিল আছে তো উনি তো বলছেন
My lord, keep it tomorrow, my lord. I will, my lord, trace the decision, my lord, and check the law.
One decision will be highly solicited.
My lord, the lordship will kindly give
One
one.
decision in this regard will be appreciated, will be accepted.
My lord, only one day's time.
Come with one decision.
My
No,
lord,
not,
The High Court.
one day's time, my lord, tomorrow.
One
I
day's
will come
time.
up, my lord. Tomorrow, lordship will consider. Only today, lordship is sitting tomorrow also.
You are so restless. You mentioned the matter several times.
নোটিশ
The
না
bench was facing a problem. Now, when the matter is taken up, a question is put. Actually,
they had not put us on notice
Question did arise on the last occasion. My lord,
then they had not put us on
in
notice
fact, a reason, my lord.
any application before us. Are you not taking out any application before us?
my lord, I would like to come up with applications, my lord.
সোমাকে জিজ্ঞেস করছে আর নট টেকিং এখন পর্যন্ত আমরা করিনি নো ডিসমিসাল ও আচ্ছা আমি বুঝতে পারি বাট নট ইয়েট মাই লর্ড বিকজ
Are you not taking out any application?
উইল টেক আউট We will take out, my lord. We'll take out. We'll take out. Not yet we had done, my lord. We'll take out.
But dismiss করছে না তো। না,
People want to time now or not related.
delete করে দেবো।
এই আমার নামটা দিয়ে দিয়েছি তোমারটাই উপরে আমার থেকে নিচে থাকার কথা ছিল আমি বলছি তো
কথা দিয়ে দিলে
এইটা উপরে দাদা ওই উপরে উপরে নীল রঙের মানে the blue one is also there.
ঠিকই তো চলে এসো আমি হোয়াটসঅ্যাপ করে দিচ্ছি আমি চলে আসবো শেষ মুহূর্তে না আমি চলে যাই আমি বলে এই জায়গায় চলে
Tienes un venido de que aquí. Nadie ha hecho chao, todo.
অর্ডার দিয়ে ব্যাংক অ্যাকাউন্ট অপারেশন স্টপ করেছে রিলিজিয়াস ট্রাস্টের রিসিভার ব্যাংক অ্যাকাউন্ট অপারেশন স্টপ করে দিয়েছে এমন কন্ডাক্ট যা খুশি তাই করছে কারোর ভাড়া নিচ্ছে না ইলেকট্রিসিটি বিল দিচ্ছে না লোকাল পকেট থেকে রেখে দিচ্ছে রিমুভাল অ্যাপ্লিকেশন পেন্ডিং
Timing, we shall come.
Sniper has come. Station
Form of application.
দেখেছি এটা হয়ে গেছে পরেরটা দেখি application when granted application for review in the court consultation হ্যাঁ with muted is muted হ্যাঁ muted is muted changes but not as in total not same with necessary
আমাকে বসে বাড়াবাড়ি করিস না
এখানে দেখুন তো ফর্মটা আছে ফর্ম এই পেছনেও তো ফর্ম এইখানটা দেখুন 47 47 অ্যাপ্লিকেশন করি করে দিন না
ঠিক আছে টাইমে নাও না আগে
time to application নেওয়া মানে time নিয়ে না।
Calcutta law and judgment and have to confront it. You have to say the law better.
2 days time.
One day. The bench is sitting. It's 1 day, 2 days.
Yes.
My lord, in the event, my lord is seeking application, my lord, I would like to come up with applications, my lord.
1 day time, no.
Yeah, this is kind of, my lord.
Tell the law tomorrow what is that has been done around 1 day's time.
না অলরেডি দুদিন মামলা করে ফেলেছি
বলেছি তো
My lord,
time,
we are opposing to their leave that they are requesting. My lord, already for 2-day consecutive hearing was made. Lordship knows, my lord, and this is a and my lord, they were my lord, they are not, my lord, they are not, and my lord, আবার বলছে mislead. They are not remediless, but the review. It is not only the, it is not the only resort for them to available. But the learned single judge, my lord, restrained the bank account operation of a religious, of a receiver of a religious trust.
He is addressing
And
on
my lord,
merit,
no,
my
no,
lord.
I am
My lord,
not
I
going to
didn't
merit,
get the
my lord.
opportunity of
And even-
replying him, my lord. That's the question.
But 2 consecutive days there.
Yes, sir, obliged, your lord. Why are you so impatient? The time we would get the time. You would not dismiss.
Even আমরা বলবো নাকি already applied for leave দরকার they already applied.
জাজমেন্টটা কোথায়? ওই জাজমেন্টটা
No, no,
না না
এইটা তো
হ্যাঁ এইটার কপিটা নেই
And my lord, they had already considered to the order of this honorable bench.
they
my
have
lord.
applied to the single bench
They have applied, they have made a hearing before the single bench after
obtaining
this
leave.
order for obtaining leave. দাও দেখি কি রে ভাই রেডি হয়ে আছে না Yes, my lord.
কোনটা দিয়েছে এইটা ঠিক না আমি আমার থেকে ছেড়ে দিচ্ছি
না আলু চাকটা দিচ্ছি
Based on what?
My lord, my lord,
On what grounds? There are 2 or 3 grounds of
Yes.
review. On
Yes.
what ground?
yes, yes. May I place these grounds? My lord, for first, my lord, the,
In an abstract manner.
yes, my lord,
To know order 47 rule 1,
obliged.
there are grounds for review. What are the grounds according to you? Then we'll go into the fact.
Yes, my lord.
I just wanted to know that ground.
The first ground, my lord, I am taking, my lord, that the law on this point, my lord,
I'm talking about, please.
Yes, yes,
you are-
ground.
You are a counsel. Now I am game because you are not matching the wavelength. Is it founded on the error apparent on the face of the record?
obliged.
Is it founded on a discovery of new and important documents which despite due diligence was not within your knowledge? I'm talking about these 2 instances. On what ground it is founded?
Yes, my first ground is that error apparent on the face of the
Is that means only ground or the second ground is also
Yes, there are other grounds as well.
what? Discovery of new documents?
Not, my lord, not in that way, my lord, but the I couldn't able to place the facts, my lord, which is necessary for the purpose of hearing of that appeal, my lord. There are decisions.
Who argued the appeal?
My lord, Mr. Surojit Samanto, senior advocate, addressing the appeal.
Address?
My lord, he appeared in this matter. I was also appearing along.
Appeared in the matter. Who was the advocate and record?
My lord, at that, my lord, Priyanka Gop was advocate on record.
Now who has filed the review?
My lord, after my lord, Mr. Srimati Priyanka Gop also initially filed the review application. Then, my lord, there obtained a change, my lord. Now the present is Narendra Gupta is advocate on record. He was present on us.
That what facts were argued and what facts were not argued.
Yes, my lord.
You were not there.
Yes, my lord, I was there. I was also appearing in that matter.
You appeared at the time of main matter.
Yes, my lord, I appeared.
You were assisting Mr.
Shamunto. Mr. Shamunto, I was assisting.
You were assisting someone.
Yes.
Mr. Sawan.
Yes.
Okay.
May I place it? My lord, the first is that error apparent, my lord. My lord, what I submit, my lord, the decisions rendered by the Honorable Supreme Court in AIN 1964 has been inadvertently not been considered by this Honorable Court, my lord, at the time of delivery of this. My lord, it lays
ground for review.
Yes, my lord, because it
makes whether there are two distinctions I am giving you because I find our wavelength is not really frequently matching. Suppose a order without noticing a judgment is passed. Is it an error on the face of the record or it is an erroneous decision?
With respect, my lord, that is the ground of review, my lord. There are decisions.
Sir, according to you, what terminology should be the appropriate one? A judgment of the Supreme Court was unnoticed. Whether that judgment, which is delivered unnoticing the judgment of the Supreme Court, will be branded as an error apparent on the face of the record or can be branded as an erroneous judgment or illegal judgment.
With respect, my lord, this is error apparent on the face of record because of the.
Can you show me one judgment?
Yes.
Except one of our High Court and one of a Supreme Court, subsequent decisions are against higher forum judgment.
Yes, may I place it?
Higher forum judgments are against. 64 is a parent judgment on review.
Yes,
no doubt about it.
Yes. Judgment consider current. Konta? 1047. Copy.
Was that 64 cited before us?
No, my lord.
Yes, it was cited.
64 was cited.
But not considered, my lord. Perhaps not. It doesn't appear from the.
Have you stated anywhere in your, because I know me very well.
Yes.
If any judgment or any argument is advanced, my principle is that I always deal with that.
Yeah, but perhaps inadvertently, this has not been considered, reflected in your lordship's judgment.
If it is cited and not considered, I believe very difficult to digest. At least me. That's my very first principle that I decide. Whenever is cited, I deal.
That's a mistake. It was cited. On order 40, one judgment came from that side, 2015 5 SCC. My lord, they didn't even ask for any chance to deal with the same, but they have given a leveled an allegation that they have not been given the scope.
Look, I'm placing it, the decisions. হ্যাঁ কিন্তু এটা নয় ওই যেটা রিভিউয়ের গ্রাউন্ড যেটা ওইটা
Where you have stated in your step that this was cited. Which paragraph?
Paragraph 2, subparagraph 1, my lord.
Paragraph
2. Note the instant review application has been filed.
You did not have.
I'm not doing it.
How you have verified this paragraph 2(1). And 2(2).
Six to two based on information.
Records.
Order থেকে দেখা যায় বোঝা যাচ্ছে না অর্ডার থেকে বোঝা যাচ্ছে ইনফরমেশন
ঠিক আছে।
is are based on information on records.
The information on record.
The order.
Gentleman who himself was present at the entire course of hearing, who is a deponent of this application, does not know information from the record, or it should be true to the knowledge.
My respectful submission is that the order under review doesn't reflect that
But you have said that it was cited and placed and omitted, and due to oversight did not consider this judgment. It is the statement which has to be affirmed as true to the knowledge, showing that it was cited.
1964. I'm sure they did not. Enough opportunity.
And the deponent himself was there.
Yeah.
So then
Judgment shows it is not. That is required.
My understanding is that the order under review doesn't reflect the decisions that has been cited.
This is one thing, sir.
Yes, I understand.
First thing is that you cited this judgment before the bench. It's a statement of fact. If it is a statement of fact, then the deponent who himself was present when the entire argument was advanced, did he not say true to his knowledge that I know I was there?
Yes, I understand. What fell from your lordship?
Off the record means what? What do you mean by and information from whom?
From the order under review,
That information, you say information or something derived from the record. Tell me who gave you an information to the deponent that it was cited and what appears from the record.
Records, yes, the order. The order under.
My lord has rightly pointed out, I don't.
How you have a verification portion. Have you seen that? And that too part. I do not know which part you want to talk about. You say, and those contained in paragraph 1, 2, 1 part and 2 part. And then you say are based on information / records. which I verily believe to be true. So there are two things. First thing is the deponent must have been informed. Informed by whom? If the deponent himself was present, then he should not be informed. And if we say based on records, then the records have to be produced in this regard.
Yes, my lord, by record, I mean the order under review, my lord, which didn't.
Citing of AIR 1964 Supreme Court judgment.
Yes, my lord.
I'm talking about that fact itself because you have founded your review on that basis that 64 Supreme Court was not considered. And it is an error apparent on the face of the record. I am just talking about this fact, how it is to be verified.
My lord, may I submit one thing? In that event, my lord, will your lordships call on the records so that
What records?
records of the appeal here
What
for
records?
the purpose of whether I cited or not?
Where it will come?
Before your lordships for the
Where it will come? I do not know.
before your lordship for the purpose of ascertainment whether I place
You are a counsel.
for the purpose of hearing of these review applications whether the 64 decision has been cited.
Show us the law. Show us the law.
My lord, that
64. Let us see.
is 66.
And the law that this is a ground for the.
Yes, my lord. My lord, may I place first the 64 Supreme Court, my lord?
It will come to your lordship, remember.
Lord, my lord, I understand, my lord has gone through this decision on several occasions, my lord, but I would like to place it.
Definitely, because I have also taken this point.
Yes.
When a review application was taken out challenging that order of DA, this was the foundation of that.
Yes, I understand, my lord. That's
Yes.
my lord, but for my satisfaction, my lord, I would like to submit from paragraph 13 these decisions, my lord. May I read for your lordship?
I have a different way of reading the judgment. So just have a patience.
এটাই তো আছে ঠিক আছে প্যারাগ্রাফটা লিখো প্যারাগ্রাফ 12 এইটা দেখেন 5-4 ওটা দেখো পড়ে তো পড়ে প্যারাগ্রাফ কোনো এইখানে না এইখানে আচ্ছা এটা বেটে গেছে স্ক্রিপ্টটা কমপ্লিট করো একটা কপি করতে হবে 5-4 কপি কভার খারাপ That's good. Put it down. Lovely. দেখাবো তো order-টা, আমার টার্মটা পরে
তো অ্যাড্রেস মেইল কি করতে ওটা তো আছে
হ্যাঁ পরে আছে।
ওরা বলছে বাকি চাইলে রিটার্ন
ওটা পরে দেবেন, আমি ভুলে যাবো, বুঝেছেন, গুলিয়ে যাবে।
2015 আছে, তারপরে সাবস্টিটিউট
এটা মনে রাখবেন।
binding cited. That is a no. 5 powers, that bit, put the power 22. And I mean, particular hard, but you play that. That's all for a doctor. Important cost protection beach. What I said, what a mistake I'm putting.
Yes,
And
it's not that. This is paragraph 13 of the SCC, maybe of AIR paragraph 12.
yes, Milot, the particular portion that I am relying on.
Yes, the paragraph, I think, begins from the next question is, I think, you're trying to rely upon this paragraph.
The next question is the
You are having an SCC or
Milot, I handed over a copy for
it's an SCC? I'm just talking about.
SCC on
next
Having an SCC copy?
SCC copy.
Yes, on the left hand side.
Yes, Milot, SCC copy.
So I think you are not placing paragraph 12, but 13.
Okay.
Paragraph 12 has nothing to
Yes,
do with this.
the latter part of the paragraph 13, Milot.
So paragraph 13, you said paragraph 12,
No, Milot, that's my mistakes, Milot.
13.
Yes, Milot, that's 13. 13, the latter part of the.
It's a very, very longish paragraph.
Yes, Milot. After quoting with approval, the decisions
Our
rendered
High Court
judgment, Milot. It states, Milot, later the learned judges pointed out that for the time being and for the purpose of administration of the assets and the real.
Borrowed from the Calcutta High Court.
Yes, Milot, quoted with approval. Thereafter, the Honorable Supreme Court states that the real party interested in the litigation is the receiver, and therefore there is no reason why the suit could not be instituted in his own name. Yes, in the event.
No difficulty.
Yes, may I place it for the letter. The learned,
The judge.
the learned judges then referred to a number of cases in support of their conclusion. It seems to us that the view of the Calcutta High Court that a receiver who is appointed with full powers to administer the property which is custodial legis or who is expressly authorized by the court to institute a suit for collection of assets is entitled to institute a suit in his own name, provided he does so in his capacity as a receiver. If any property is in custodial legis of the contesting parties, cannot deal with it in any manner, and therefore there must be some authority competent to deal with it. In the interest of the parties themselves, a receiver who is placed in charge of the property on behalf of a court can be the only appropriate person who could do so, my lord. That's what my submission. His function cannot be limited merely to the preservation of the property, and it is open to a court, if occasion demands, to confer upon him the power to take such steps, including institution of the suits in the interest of the parties themselves. Here, apparently, the receiver was not a person with full powers, but by its order dated June 26, 1949, the court authorized him to collect dates, particularly as some dates were liable to get barred by time. The receiver, therefore, had the right to institute the suit in question. It is, however, contended that the order doesn't say specifically that that he should institute the suit. In our opinion, this is also very important, my lord. The authority given to the receiver to collect dates is wide enough to empower the receiver to take such legal steps as he thought necessary for collecting the dates, including institution of the suit. The suit, as originally instituted, was thus perfectly competent. The High Court has observed that even assuring that it would have been more appropriate for the receiver to show the cause title that it was the firm which was the real plaintiff, my lord. That is also important, my lord, because the receiver was representing a firm, my lord. Instead, he can do in both ways, my lord. Either he can institute the suit in his own.
Who disputes this so settled proposition of law? Nobody disputes the settled proposition of law. I think there cannot be any debate on that.
Yes, yes, obliged to it.
Court has an authority to appoint a receiver if it is just and convenient in relation to preservation, protection. The powers of the receiver is enshrined under Order 47, Order 41, that what the receiver can do. The receiver definitely has a, because the moment the receiver is appointed, he, very interesting, the word you use, he is really a right arm of the court.
Yes, obliged to lordship. Obliged to lordship.
He's representative, but he also a right arm of the court. And as a right arm, he has every authority to preserve and protect. Now, the powers have to be given by the court in a particular manner. The judgment very clearly distinguishes and convey the laudable intention that the moment the court has appointed the receiver for a specific purposes, and the specific purposes connotes certain action to be taken, it will be deemed that the court has permitted him to take such action.
Obliged to lordship.
What are the purpose for which the receiver was appointed here?
Which is that yes. Yes. May I place it?
Judgment which you are citing as the double-edged sword. Remember.
Only
double-edged sword.
আমাদের appointing order
It goes against you as well.
Look, as far as my understanding goes.
That's why I'm saying in one principle you may,
Yes.
in another you may not. It may go against you.
In
the same paragraph.
Yes, Milord, one respectful submission I have. Milord.
The thing is for what you were appointed.
Yes, Milord. Milord, my respectful submission.
To preserve, protect the property. That's all.
Yes.
Trust what? What was the dispute?
Yes, Milord.
Ordered well, not even for preserving or protecting the property. The words verbatim as in the order, but the order of the
Placing an order.
yes, my lord.
Appointing the.
But the discharge receiver shall hand over all the documents of the newly appointed receiver. Newly appointed receiver shall submit a report on physical condition of the trust properties, name of the occupiers, payable rent / occupational charges, outstanding amount of the rent, and the accounts of the trust estate on or before the returnable date. Full stop. The receiver, the statement of accounts such and such shall also be filed. This is
Thereafter, any modification of the order.
only one line for the time being. Yes, my lord. No such modification. Yes, subsequent order, there no modification, my lord. May I show?
That's the only.
That's the only. Order will I show?
Milord, what happened, Milord? Perhaps I couldn't place all the orders relating to the appointment of the receiver. And yes, Milord, possibly the reason why your lordship has the erroneous impression against me with reference to my power.
No. What is the only order?
Yes.
Appointing this document as the receiver.
Yes.
Forget about the other.
Yes, Milord. Milord, I shall place
trying
it.
to
Appointed a receiver for a particular purpose. Then this purpose has to be understood.
the parent order, the purpose is specified.
Parent order appointing another receiver may have a vice.
Yes.
But this order, when he appointed the
Yes.
first receiver, has to be construed.
Hmm.
For what purpose it is?
Milord, what
The parent order for this receiver.
Milord, what I submit, Milord, that there was a receiver already in the property, Milord, for a long time. Milord.
Subsequent
the-
order, receiver was proscribed from. Oh,
Since the year 1987, Milord. Time to time, several receivers were changed, Milord, after death of the earlier receivers, Milord. And subsequently, the new receiver was appointed in the place and state of the earlier receiver, Milord. And the earlier receiver, Milord.
We will not go into this. Any other judgment you want to cite apart from this 64?
Milord,
Just to bring a quotus to your argument.
Hmm.
Any other judgment you are relying on?
Hmm.
64 you have relied.
given 2015 5 SCC.
No, এটা পড়বো।
And in that light, my lord, given 2015 5 SCC 539.
Just wait.
না, ওটা
জজ সাহেব জানো, জজ সাহেবই দিয়েছি।
64 decisions are Milord, on this point, Milord, we
This is, you have to conclude the argument.
yes.
Both you have to say that apart from 64.
With reference to the power of the authority of the receiver, Milord, I rely on 1964 decision, Milord.
64.
Yes.
And no, we are talking about two things. Whether 64 was cited before us or not. If it is cited before us, not dealt with, we'll consider. Anything more, because review, the jurisdiction is.
Yes, I understand, Milord.
Anything more, what is the further error apparent on the face of?
Yes, Milord.
Because that is the only ground you have taken.
Milord, I am seeking one short leave, Milord, to place the decision, the orders of the learned trial court conferring the power and authority upon the learned receiver, Milord, in this matter, Milord, because it.
On this receiver.
Yes, Milord.
On this receiver.
Yes, Milord, because it gave the wrong impression, Milord, an erroneous impression
These
upon.
are the part of the records you care.
Yes. ওইটা দিয়েছি।
Give them a copy so that
Milord, they have all these.
they have
Date টা বলো?
26 February, give them
26th February.
26 February.
26 February. Yes.
Mr. Dev, learned counsel for the newly appointed receiver, candidly submitted and reiterated that the newly appointed receiver, Mr. Indranil Roy, may be released from the assignment. He handed over the checks, such and such. Since Mr. Roy is not willing to act as receiver, he is released at once. And
Then
Yes.
then
In
view of the release
yes,
of
in
Mr.
view
Roy,
of the release of Mr. Roy, no one is there to administer the estate of the trust. Mr. Mitro for the plaintiff administer the trust. This is very important. The plaintiff submitted that Mr. Ashok Gupta, learned member of the public club, may be appointed receiver in place of Mr. Roy to administer the estate of the trust. Let Mr. Gupta be appointed as receiver as a stopgap measure since a review application GA 124 along with such and such is pending for adjudication. Appointment of Mr. Gupta is subject to the outcome of the review applications. It gave the respondent perhaps they want to stretch at one.
he's appointed. Then what?
Milord,
Read further.
yes. Appointment of Mr. Gupta is subject to the outcome of the review application. Yes. Mr. Gupta shall receive remuneration such and such. The newly appointed receiver shall inspect the trust properties and submit a report on physical condition and name of occupiers. The report shall be submitted on or before such and such date. Milord, I respectfully submit, Milord. Milord,
Got your point that once you were substituted, then whatever the powers the earlier receiver has is also given to you.
Obliged to
with
Lordship.
an additional power which is there in the last power.
Obliged to Lordship. Milord, yes, one.
If you think, if you open a mouth, I
Yes, yes, I understand. Milord, Milord, my.
This is what you argue.
Yes, Milord.
No, that is the order.
Anything more?
Milord, what I submit, Milord, yes, Milord, what I submit, Milord, respectfully, that it gave the wrong impression as if the receiver is a stopgap arrangement.
Or a writing.
But
continue.
Show us anything more.
Yes, Milord, paragraph 7, page 17 of my applications, Milord.
Yes.
The relevant part is starting from
This was the order which was essayed before us.
Mm.
Not order.
No. Yes, page 18, Milord, the relevant part is that the review application is filed by the erstwhile receiver appointed by this court challenging the order of review of the order passed by this court on 19 December, whereby the master summons was allowed, recording the date of the petition number 1 substitutely.
Who has filed this?
Milord, this is an applications, Milord.
Erstwhile receiver.
Erstwhile receiver took the matter to the division bench for review applications, Milord. His review application was dismissed, and hence the erstwhile receivers in place and state of the erstwhile receiver, the newly appointment of the newly appointed receiver was confirmed, Milord.
It was Mr. Roy who took out that application.
No. Mr. Ghosh, Pinaki Ghosh.
The erstwhile receiver, Pinaki Ghosh.
Because Mr. Roy, I find.
Yes.
Indranil Roy.
Yes, he appeared.
So before Indranil Roy.
Yes. Exactly, Milord.
He filed.
Yes, Milord. After dismissal of his review application, Milord. Contentions in the obliged to Lordship.
Anyhow, so review was dispensed because it says that he's not a party agreed. And then
Now, the last paragraph is very important. In page 19.
the erstwhile receiver is directed to reopen that he has gone. Erstwhile receiver preferred an appeal against his order of removal. Anyhow, he is directed to open the padlock, hand over the position to the present receiver.
Obliged.
Means Mr. Roy.
Mr. Gupta. Mr. Roy did.
Oh. Mr. Gupta.
Mr.
Single order that then he will continue as a receiver.
Then what is the appellate court's order? That is our order.
Not in this matter.
This
The
is
erstwhile
subject to the order as may be passed by the appellate court.
the appeal got dismissed, Milord, and his.
When, who passed the appeal? Appellate court. Who was the appellate court?
Milord, page 19, Milord. The present receiver, Mr. Dashgupta, appears.
And what is this meaning of it? Since there is no order of stay on removal of the erstwhile receiver, the present erstwhile receiver shall continue.
This is perhaps inadvertently this word has been imported, my lord. The very next order, my lord, page 20, my lord. This has been corrected, my lord. The relevant part is on page 21, my lord, in the second paragraph. In the first line of the third paragraph at page 3, has my lord got it?
Yes. So present receiver.
Present
And
receiver. My lord, what I respectfully submit, since there is
the present receiver was appointed on 26 February.
obliged to learn.
These were the orders subsequent to 26 February.
Yes, my lord. This is otherwise very important, my lord. In page 29, my lord, since there is no order of stay, the removal of the erstwhile receiver, the present receiver shall continue to work. Means his appointment was confirmed and affirmed. He is no more a stopgap.
Page?
19. Page 19.
19 I have got.
My lord, what I respectfully submit, he is not a stopgap arrangement for the purpose of the property, my lord. He has been conferred with full power the erstwhile receivers for the purpose of the administration of the property of the trust.
There is no express appointment.
My lord, it gave, my lord, the respondent, my lord, erroneously, my lord, perhaps deliberately gave the
Only inferring to confer jurisdiction on the receiver.
Yes. Then
My lord, my respectful submission is that his power
then
and
what is the order which was received before us
yes.
after 10th April?
My lord, I humbly submit, my lord,
I am asking you, please show us the order which was received.
my lord, I must, my lord, My lord, before that, my lord, just one line, one sentence, my lord, I beseech you, lordship. My lord, it's on page 31, my lord.
I have read it. Thereafter, that's why I say.
The leave is granted.
I have seen.
Obliged to it.
Show us the order which was received before us.
Yes, my lord, it starts from page 32, my lord.
16 July order. Yes,
Obliged to
I have
it. Yes, my lord. My lord, they took out a recalling applications. Actually, this is an application for removal of the receiver. Yes, my lord. I assailed this order before your lordships, my lord. My lord, the very first ground, my lord, that no copy of the application was served upon either the respondent or the receiver before passing this. This is the first, my lord, ground of appeal, my lord. The second one is that, my lord, this is an...
Who are you? Are you a litigant?
Yes, my lord, I'm the sole respondent before the learned.
Right arm of the court. If the court with the right arm signed the order, that's enough in view of 64 Supreme Court.
That's why the court express order stopped their bank account operation.
The court will not hear you. If the court wants to hear you, will hear you. But as a receiver, the court is responsible for every act because the property is in custodia legis. The court actually assumes, as per 64 Supreme Court, title for the time being. Why you should be served with the court? If there is an allegation, the court will definitely direct the service. The court can definitely, he is the one who appoints you as an authority to restrict you.
May I submit, my lord?
The court took the exact observation and thereafter they had filed an application for releasing of the matter from Justice Sugata Mujumdar's list. Then my lord was compelled, in open court I'm saying, was compelled.
May I submit, my lord, with
Cutting
reference
a
to
sorry figure, my lord was compelled to release
what fell from your lordship? May I
this
submit?
receiver.
May I submit, my lord? My lord, the trust
In the
in the application, my lord, suit is the sole respondent before the learned court below. My lord. someone should represent on behalf of the trust for the purpose of the well-being of the trust, my lord. The reason why the learned code below, my lord,
It's trustees,
no,
though they are not. This for respondents, it appears, who is appearing representing the court? Mr. Devraj Bhattacharya.
yes, my lord, representing the trust, my lord. We were, but
Once the
Mr.
receiver,
Chakravarti
once
is
the
present, or my lord, I myself is.
That's
Once
all.
the receiver,
You
once the
were represented on that day.
Yes, my lord, but no copy of the application was served.
Fair enough.
My lord, the first thing, my lord, in an adversarial system of justice, my lord, there cannot be.
Who are you? You are one of the trustees or?
No. They are not. They are beneficiaries, my lord.
My lord,
There is a general public, my lord.
A general-
They have no connection with the trust, my lord. Because
Even
people are all
receiver is
every
managing the wheel for in the process of formation of committee of management.
my lord, all people, because it is a
He
public
will remain for time
religious trust.
immemorial. No committee he will allow to form.
All public are, my lord, the beneficiaries, and he is one of
This
them.
is the conduct of this receiver. It's the rarest receiver in the history of the High Court.
That was my argument.
Yes. Anything more?
Yes, my lord. In an adversarial system of justice, my lord,
You are entitled to a copy. We will consider.
no, I should represent, my lord. My lord, I may submit, my lord, trash, but let the court hold that I am nonsense, my lord, and pass an order, my lord. But before that, my lord,
Next, yes, I got the point.
yes, my lord.
It is not possible.
Yes, my lord.
What is the point of the
Yes, second, my lord, that
review?
the learned judge on that very day didn't have the jurisdiction to hear this matter, my lord. The first, my lord, my lord,
That
has been dealt with in our appeal.
yes. But, my lord, I didn't get the opportunity of making submissions with reference to the merits because
according to you, that he passed the order without affording you an opportunity of it.
yes, my lord, with reference to the merit of the appeal, my lord, with reference to the merit, because several observations has been made with reference to the appeal.
So this is the third ground. Fourth,
Yes, my lord, the learned judge didn't have the jurisdiction on that very day.
consider it, sir. We are in review. What the learned judge has done is immaterial for us. We are more concerned with our judgment. We have to see whether you were afforded a fullest opportunity to argue on merit. If it is not, then it attracts a provision for review.
Yes, obliged to it. That's it. That's
Any other
my,
point?
yes.
Any other point?
We could have
We are on
gone to
review.
SLP.
It's not going to the merit.
Yes, my lord, as I didn't get the opportunity of,
I told you. Why you repeating?
no.
I take it. And this is the third ground. Fourth. What is the fourth ground?
My lord, আচ্ছা এটা কোথায় আছে এটা ওই স্টে অ্যাপ্লিকেশন মিলট ইন মাই মিলট
কত হচ্ছে 41
মিলট ইন মাই মানে প্যারাগ্রাফ 1 of my stay applications মিলট এটা তো না, এটা
supplementary affidavit.
oh milot in the supplementary affidavit filed in connection with the appeal milot in paragraph 1 milot I submitted milot that this is an application seeking removal of Ashok Gupta advocate receiver, consequently seeking recalling applications. The learned judge attracted the jurisdiction of the learned court below, holding that it is a recalling application. So, but the prayer, the pleadings as made in their application, G18 application.
What was the prayer?
Milord, the first prayer.
Prayer in the GA was what?
Yes, Milord, I shall place it. Milord, prayer A. Delay, if any, filing this application be condoned by this honorable court. Mr. B.
No, in the trial court.
Yes, this is a application G18. B. Mr. Ashok Gupta be removed from the post of the receiver, Srimati Charushila Trust Estate, having his office at 10 Old Post Office Street. This is a prayer B. This is a removal applications. Consequently, prayer C. the portion of the order dated February 26 passed by the Honorable Justice Sugato Majumdar in GA 10 and GA 13, both arising out of ACR number 2217, may not be recalled to be, may not, a suit for eviction, my lord, with a consequential player for damages doesn't become a suit for damages. It's a suit for eviction. It's a suit. It is an application out and out for removal of the receiver, my lord. It's not a recalling application. It can't be.
Super hyper-technical pleading destroys the interest of justice.
You are making a passing remark.
No, they are always in the habit of doing this, my lord. They will not allow me to make submissions.
Now have acquired substantial years of practice. We should restrain. The juniors will
Very well, well, let him
prompting every time.
let him talk.
Yes, then fourth ground. Fourth ground.
Argument may not consider. That is the application for removal, not a recalling. That is the ground. Argument may not consider that, but do you on the very first day this
হ্যাঁ এগুলো সব প্লেস করেছি
না ওটা করেছো
এই যে আপনার অ্যাপয়েন্টমেন্টের কনফার্মেশন
it was appearing as the application the bill was dismissed.
না না সেটা উনি তো বলছে
বলছো তুমি তো বলো না that is the ground. That's a mistake of the court.
না না সেটা
Appeal was dismissed. The appeal court.
না না এটা দরকার নেই হিজ অ্যাডভোকেসি আস্কিং ফর অ্যাডভোকেসি অ্যাকচুয়ালি
আর আছে the materials on the court were not considered.
No, no, that's gone.
It's not a recalling application. Argument not considered.
হ্যাঁ আরে না না আরে ও আমরা অ্যাপিলটা কেন করেছি গ্রাউন্ড পেইটের গ্রাউন্ড
Yes, next point. Sir, this is not a forum for consultation. You should come ready. We are taking up all the matter patiently. If you are not supposed to waste the time in this way, that you are consulting in the midst of a year.
I am obliged to lordship. Kindly will not appreciate my predicament.
No predicament. You are a very veteran member of the bar.
As far as I understand,
years of practice. Know how to conduct in the court. You know how to present a case. You know how to argue a matter. I need not have to remind you.
Much obliged to lordship.
Just I am reminding you for this. Give me your fourth point.
Yes, much obliged to lordship. As far as my understanding goes, the impugned order of the learned trial judge, suffers from.
We do not want to go, sir. We are concerned with our order.
Yes, that has not been considered.
Forget about it.
Yes,
our order.
Yes,
what is the error? Again, 3 points you have raised. Fourth, tell us the error.
All these arguments have not been considered.
Not. Then that the full argument was not applied. Fourth point.
Just said non-maintainable decided on the merits.
One more point, if my other appeal is not otherwise maintainable, there cannot have any observation with reference to the merit of this appeal,
These are all the passing remarks. So fifth.
Yes, if your lordships.
I'm not jotting it down so that while dictating I can. At the points, bullet points. Point 1. The review is
this decision
the
কোন কোন প্যারাগ্রাফ দেখাচ্ছ?
না এত পাতলা নেই। কি নাম কি মামলাটা?
এই নামটা বলবে?
Milord, I am relying on Milord.
We will rely upon later on. Let me first read.
Indian Church Chrome Limited.
ওটা দেখো, দাঁড়ান, এটা হয়ে যাক।
ও একটা পয়েন্ট আছে, ওটা ভুলে গেছি, ওটা ও বলে the learned judge who
এটা
ফিক্স ম্যাটার হচ্ছে।
yes,
Milord, in support of to
yes, you are relying on paragraph
15, Milord, summed up in paragraph 15, Milord. Milord,
already read.
yes, Milord. Milord, one clarification, Milord, I'm just citing some decisions, but the learned judge didn't have the jurisdiction because it was a removal of the receipt.
That I will take. This is a bullet point which
Yes,
I have. When I come, I will dictate. Don't
Obliged, outside.
open for. I will not dictate
Obliged.
it anywhere.
Yes.
Don't.
এটা আর কপি আছে?
So that I may not miss anything, I have just recorded the bullet point which you have.
Milord, I also rely on Milord these decisions, Milord.
Yes.
Constitutional bench of the Honorable Supreme Court, Milord.
Yes.
Paragraph 13, Milord.
Aman Singh is a gentleman of quoted that.
Yes.
Please.
Paragraph 13, Milord. I am relying on Milord.
Citation-টা বলো? প্যারাগ্রাফ কত বলছো? প্যারাগ্রাফ কত বলছো?
13.
Have a bad grooming. I see here rules of you. Whenever the judgment is cited, you should read the whole judgment.
Yes.
From the first.
Exactly.
So let me read it.
Yes, yes. No, he is asking for
I
Milord.
told that.
Yes, yes, I understand, Milord.
I told.
This is a lesson to be learned, Milord. I understand. It is copy. এটা একটাই কপি আছে। Archit, that. একটাই দেখাচ্ছি এটা দেখানো দরকার আচ্ছা ঠিক এটা ডিভিশন বেঞ্চ তো ভাস্কর এটা
You're relying on paragraph 13.
প্যারাগ্রাফ 15
13 of the judgment which you cited. Which paragraph you want to rely? You have cited this judgment of Daman Singh.
Daman.
Which paragraph you are relying?
Yes, my lord, I'm coming. Daman Singh. Daman Singh. My lord, paragraph 13.
That is what I.
Yes. Applies.
Yeah, yes.
Yes, my lord. Rajinder Singh. My lord has gone through these decisions as well on several occasions, but perhaps for my satisfaction, I'm giving. My lord, what happened, my lord?
Remembering Rashmi Methodic's judgment of the Supreme Court also in mind.
Yes.
The Supreme Court, paragraph 6 or 7, have made certain observation on the responsible arguing counsel of the bar.
My lord, in this, my lord, I have got one copy and another copy. It has been marked, my lord, if my lord permits me.
Yes.
Citation paragraph? Paragraph 15, my lord.
13 to 89 একটু দাঁড়াও এরপরে আরেকবার দেখো
Paragraph 15 and 16, my lord. I'm relying on in support.
প্যারাগ্রাফ কত বললি
Document which forms part of the record, material documents were overlooked by the court.
Yes, my lord.
Error apparent on the
And the High Court inherits every court of plenary jurisdiction to
That is
prevent.
what is emanating from the off-quoted judgment of EIR 1954.
Yes, my lord, on last occasion, I remember, my lord, it also fell from my lord, that your lordship has the plenary jurisdiction.
Every high court has a court of record.
Yes, my lord.
Article 250.
Yes, my lord, exactly. That what fell from on last occasions, my lord. And the reason why I submit, my lord, is for my.
It's not there. Then what for? Any judgment?
Yes, my lord, a further decision, my lord.
You should not leave anything in your kitty.
Yes, it had. দুটো আছে
But we will rely on a Rashmi Metallic. Just bring out that Rashmi Metallic judgment of Justice Vikramjit Sen.
বিক্রমজিৎ সেন
Yes, which paragraph you are relying on?
Paragraph 10, my lord. Look,
No, this is what is well known.
well, yes, I understand.
Then
Without going into niceties of the
Acha.
much.
It had
Then-
got- Paragraph 4 and 5, my lord, in this matter.
কোন জাজমেন্ট এই জাজমেন্টটা বলো কোনটা দিচ্ছ 9 12 3 and 8
paragraph, paragraph four.
4 and 5, my lord.
Yes. Next.
Yeah, yes.
উপরেরটা আরেকটা জোর বল নে 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 দেখ না হ্যাঁ 10 দেয় না
What by judgment?
But we are finding it out. Yes, madam.
Either Rashmi or Reshmi, I do not know. R-A or R-E?
R.A.
You know, I'm relying on.
Authored by Justice Vikram is same.
কিছু বেরোবে না
এটাতে কোন প্যারাগ্রাফ? Look, this is otherwise a long decision, my lord.
You are not afraid of any talk or a short.
Yes, my lord.
Only the decision which must be relevant.
13 10 SCC 95 বললাম
Paragraph 6 or 7 is there.
এখানে তুই বার করেছিস বলছি তো এটাই এটাই
Look,
এটা বিক্রম জিতছেন তো এটা তো সেই
Some advice to the member of the bar you will find in paragraph 6 or 7.
বিক্রম জিতছেন
my lord, I'm relying on in this matter, my lord, paragraph 29, my lord. To sum up, it starts with. Yes, my lord, my lord, that's and through
13,
it,
10
you
is
understand, my lord.
There is 2013 10 SCC page 95
Referring to paragraph 7.
That's why you say 6 or 7. Please
6 or
remind.
There are
13
10 SCC 95
So let him go through it. Let him go through it. এটা দিয়ে দাও
দেখবে there are 7 জজ সাহেব
না, এটা বলছেন judge।
এ মারা গেছে
এটা না, এটা কি বেরিয়ে গেল?
হ্যাঁ কি বেরিয়ে গেল আসলে
কিচ্ছু পাবে না।
only it's court and even 7 আসছে না
এটা judge করতে বলছে।
No, it is irrelevant. What he says is correct because according to him, everything is irrelevant. It is also
No, this is not
irrelevant.
my submission.
Relevant for you. Not print out. Please. Relevant for you. Don't worry.
যদি দাদা
For your own introspection.
পরে নিয়ে আসিস দাদা
Court and the High Court as well as the subordinate courts have to face lengthy argument in each case because of the practice of citing innumerable decisions on a particular point of law. The correct approach is to predicate argument on discussion which holds the field, which is the present case in Tata Cellular versus Union of India, rendered by the 3 judgments. The rule of procedure, which is an integral part of our jurisprudence, mandates that the exposition of law must be followed and applied even by a coordinate or co-equal benches and certainly by all smaller benches and subordinate court. We hasten to clarify that if a coordinate bench considers the ratio decidenti of the previous bench to be of doubtful efficacy, it must comply with the discipline of requesting the Honorable the Honorable the Chief Justice to constitute a larger bench. Furthermore, there are some instances of decisions even of a single judge which, having withstood the onslaughts of time, have metamorphosed into high authority, demanding reverence and adherence because of its vintage and following a contradiction of the strength of the bench. This is to significant characteristics of the doctrine of the stare decisis. Tata Cellular has been so ubiquitously followed. Yes, yes, 70.
Only 7. Nothing to understand.
Has it followed one decade
Remember, you not understood, return it back.
in almost every case concerning government tenders and remains with it states
You have understood, fair enough. Keep it in yourself. If you are not understood,
Milord, what I also
is what?
yes, Milord, what my lord is reminding me, Milord, that I learned from the seniors that the best one should be cited, and that's enough.
Thank you. Full sentence শুনতো।
একটু দেখিয়ে দিয়েছিল প্রপোজাল ইটস এনাফ Milord, with reference to the Milord point, Milord, perhaps my lord remembers, Milord, that I submitted, Milord, that the application was for not for recalling. Yes, yes, yes. My lord recorded. Yes,
Jurisdiction determination.
yes, yes, yes. No, Milord, these are my respectful submissions, Milord. I submit, Milord, that in an adversarial system of justice, Milord, someone should represent before the court, Milord, and Milord, I must be granted an opportunity of hearing, Milord. That's my submission. I may be wrong, Milord, I may be erroneous, but the learned court should grant me an opportunity. I am not submitting before this court what happened, Milord, but an order has been passed against me, Milord. Yes, Milord, no opportunity is granted.
So,
Milord, particularly when the jurisdictional issue is raised, Milord, the learned court should first decide it before going to the merit or passing or any order with reference to the merit of the applications, Milord.
that's all I believe. Now, this time, you have the fullest of satisfaction that you have placed all your cards. You have not left any stone unturned. I believe so. That's satisfaction because we are live. That's why we have to be very careful, because later on that I argued did not consider, because then we'll play our live recording. So please tell us which is going on record, that nothing more is argued.
Yes, Milord, perhaps it was the application was moved, the initial application before vacation, and possibly it was in hurry, and perhaps because
If you finished your argument,
Milord,
the court's query is this.
Milord, I never had the doubt of your lordships that your
If
lord.
you finish your argument, that's final. Final. No more, no further. Then
Yes,
we can invite the other side.
yes, yes. These are my
These are your final. Yes.
yes, Milord. One aspect, another one aspect, Milord, that in a matter, Milord, in an applications, Milord, pleading should be preferred. The avowance made in the pleading should be considered with more importance rather than of the prayer, Milord.
Okay.
Yes, Milord. That's why the reason why I
The pleading has.
yes.
সাইটেশনটা কত বললো না সাইটেশনটা বল সে ভাই নারী নারী কথা কিন্তু মুখেও বলবে না
That's all.
Yes, Milord. These are my respectful submissions.
আমার no application case.
Milord, also, Milord, in one way, Milord, before
We have
Pointed what? By
Why you are, sir? Why the set of councils who are
no, he's from that side only, not from my side.
I had some eye problem. I cannot see
don't read it? You are a council. You have a leader.
No, I don't have it. I am the leader, but since I have my problem,
Anyhow, you are participating to our council. Yeah, right. He has argued with your lead.
right.
Thank you.
What point?
Thank you.
One. The final application. That's the application that is filed. That there is no indication of this application against this.
Sir, another aspect. Anyhow. Yes.
But, we are also encapsulating our submission and reforming it into bullet points. First, in reply to their submission, they may take their case at whatever high they may choose to. But at the end of the day, it is a application praying review of my lord's order, and which is a very limited and specific scope under the code. The two conditions that we had already got fallen from your lordship, unnecessary to repeat from my end. My lord, there is my submission, there is no single ground that they have pleaded, though the fault of affidavit, everything is there, though no single ground that they have pleaded which speaks of error, any error apparent on the face, rather any error apparent. Secondly, my lord, I cannot approbate and reprobate at the same time. After my lord justice has passed this order of appeal, they had applied for leave to sue before the court below, before the same judge, and they have made a substantial argument there. In my submission, they had that moment, they had considered to this order. Now they are plattering in review. I'm just 5 lines order, my lord. It is already parted and continuing. So, my lord, they cannot. I've given 2 copies, hot and cold at the same time.
After passing of the impugned.
Yes, this order, they see the date, my lord. Substantially, they have made the submission.
File application.
But at least we cannot take the court everything for granted that we choose to seek from the court. But when there is no single, if my submission, it might not be necessary or the repeating exercise to go through all the grounds. My submission, when the moment it is found that there is no error apparent, the court under review, in my respectful submission with deepest of respect, my lord, may not exercise its, rather should not exercise its jurisdiction under the review. My learned friend nonetheless opened the entire merit from 1987 to everywhere. This is not made for review.
So
because they are not
contention
my lord.
Contention is the after passing of the order of impugned order, which was challenged in the appeal.
No. Yes.
Listen to after passing of the order, which was challenged in the appeal, and even after passing of the order, which is subject matter of the review, they have participated in this proceeding.
Yes.
So they have acceded to the jurisdiction of the
considered to this jurisdiction.
Practically, they have accepted this order.
I cannot blow hot and I cannot blow hot and cold at the same time. It is not my pleasure of taste. Sometimes before this forum, sometimes before that forum. And most unfortunately, before that court, only on our pointing out, they had to make a supplementary affidavit and file this order of this my lord's appeal court in that first court, but before Justice, Honorable Justice Bivas Patnaik. Only we had pointed out Lordship's order. They had, if I am allowed to say, smartly gone and filed an application for leave, as if a receiver is going through the, going for the leave to sue. Without even, if I am allowed to say, disclosing this order. And thereafter, they have, by way of supplementary affidavit, at our pointing out and this insistence, they had gone. When my lord was saying the receiver is the arm of the court. No, error happened to, my lord, though it might be a repetition, my third point. No, Lily Thomas, দেখো জজ সাহেব জানেন প্যারাগ্রাফ গুলো বলো
1560
মানে
লিলি থমাস হচ্ছে 52 56
well known and celebrated judgment of Lily Thomas Mallet. Mallet একটু দেবেন লর্ডশিপকে আমাকে একটা কপি দে হ্যাঁ হ্যাঁ দে লিলি থমাস
2006 এসএসসি 51 থেকে পড়ো 2000
Which para is relevant according to you?
51 onwards 50
Mallet 51 onwards Mallet. I mean, I must say I have the judgment has been found out by Mr. Dasgupta. I have no credit to that. Mallet 51 Mallet paragraph. দাঁড়াও ঠিক though Mallet goes in entirety, Mallet, I'm better leaving for Mallet to read. Tracing upon paragraph 51 onwards. Joseph পড়ে নেবেন Joseph পুরোটাই পড়বেন There the court has made this observation. Review is not an appeal. Assuming they had any point, they had other avenue open.
Yes.
51 onwards, Mallet, 52. 52, 50, 54 of the khali hai. 56. And 52 ends with the recording that the mere fact that the two views on the same subject are possible is no ground to review. And the earlier judgment passed by the bench on the same strength.
single bench
This is standard. And এটা তো পুরোটাই দেখা and Malad, we have the opportunity of relying on the Makhon Chandra Das, Malad, which Malad had been pleased to pass sitting singly on this Malad. For Malad's consideration, Malad.
ওখানে আছে পুরো কম্পাইলেশনের মধ্যে আছে কম্পাইলেশনটা দাও
হ্যাঁ কম্পাইলেশনটা
তোমার কাছে প্যারাগ্রাফ ওখানে লেখা আছে ওই যে দেখো ঠিক দাও গার্ডেন এই যে না এই পরেরটা পরেরটা এইখান থেকে
এটা আমি রিপোর্টে দেখেন এই না SCC online Calcutta 3
Voted in 2013 volume 2.
Calcutta Law Times 547.
CHN.
Yes, my lord. Also in CHN there 2013 volume 3 CHN 597.
ICC also.
সেকেন্ড দেখো আমার নাম দিয়ে শুরু হচ্ছে ওইখানে
My lord, may I take your lordship to the second page of the judgment given, my lord. The last paragraph of that page. Mr. So-and-so, the learned advocate appearing for the opposite party, that Mr. Dasgupta had opportunity to appear, however, submits that the
I
review
was
under order
talking
40.
about when you were citing 64, I thought it is on review. So this was considered. I was bearing in mind the 64 Supreme Court judgment.
Supreme Court 64 is perhaps.
I refer.
However,
64 Supreme Court was relied upon by.
yes, my lord.
This last paragraph I have relied here. Yes.
Too much. If it is cited, it is always taken into consideration. And that circumstantially,
A different judgment he was.
yes, might be, but
considering
no,
that
that
this
part circumstantially proved. Mr. Suvansu, the learned advocate, appearing for the opposite party, however, submits that the review under Order 47, Rule 1 of the Code cannot be resorted for rehearing of the matter and is confined to an error apparent on the face of the record. He further submits that even the judgment under review may be erroneous, but the same is not capable to be reviewed under Order 47, Rule 1 of the Code and place reliance upon the judgment of the apex court in Tungabhadra, that is 1964-1372. He further submits that the review jurisdiction cannot be invoked to face out and search out an error apparent, to fish out an error apparent and fish out the error and place reliance on a judgment of the Supreme Court in case of Lily Thomas versus Union of India, AIR 2000, Supreme Court 1650, by contending that unless there is a patent error in the impugned order, the same cannot be reviewed. He placed reliance on a judgment of the apex court in case of Surjit Singh versus Union of India, reported in 1997, 10 SCC 592. Lastly, he submits that unjustifiable absent in participating in the proceedings cannot be a ground to review and placed reliance upon a judgment of the Andhra Pradesh. Well, this part, I believe, is not the subject matter of ours. Then, the Order 47, Rule 1, 2 is quoted, is quoted and discussed thereafter, after Order 47, Rule 2, the review is not an appeal in disguise. The court does, this is the observation of the court, the court does not make a hovering de novo inquiry to find out an error in exercise of review jurisdiction. There is a sharp distinction between the erroneous decision and decision vitiated by error apparent, as has been held by apex court in Tungabhadra. The court of review is circumscribed by the definite limits fixed by the language given therein and may be allowed on broadly 3 species of the ground, namely that all the 3 species, discovery of new and important matters of evidence which after the exercise of due diligence was not within the knowledge of the party applying for the review or could not be produced at the time when the decree or order was passed, mistake or error apparent on the face of the record, which there is nothing as, and the Roman 3, for any other sufficient reason. Apart therefrom, any important and material issue not adverted which goes to the root of the matter on which the case raised upon is not adverted, the same would certainly amount to error apparent on the face of the record. The erroneous assumption of material facts is in a judgment may render the same upon review as held in the case of Burma Shell Oil distributing company. Burma Shell case ta ache kane? In these words, where the judgment proceeds on an erroneous assumption, and the Lily Thomas, the 2005 one.
2024
Yes, Malan.
এটা লাস্ট
এটা কোনটা? এটা আছে আমাদের এটা
আছে
না আরেকটা 2024 2 HCC 362. Another one 2024 2 SCC Malan 362.
1516
Paragraph 1516. And the entirety of it, Malan, for lordships to consider.
Paragraph
15 and 16 we are stressing upon.
এই তো
না ওটা পরেরটাই চলে গেল
না না এটা আছে but very 16 is the summation. Before that 15, it is the very pertinent to note that recently the constitutional bench.
the change of law or the subsequent decision does not invite the review. That is what is
That
matter
is
15. 16 is the summarization of the.
Yes, man, that is a summation. Yes, my lord.
Not submissions.
But the summation, but the gist, my lord, that they have
Summarization.
encapsulation.
Submission.
Summation, I told my lord, not summation. I'm sorry, my lord. Summation. My lord,
Yes, I have read it.
yes, my lord. These two, my lord, that various separate.
জাজমেন্ট দেখাতে পারেনি খালি সেইটাই আছে বাকি মেরিটে তো যেতে পারে সেটা
Fact, my lord, তো প্রথমেই ওরা তো জাজমেন্ট দিয়ে শুরু করলো আর মিস্টার শুরু এইটাই আর কিছু মানে only thing মানে my the rest if my senior chooses to মানে
Complete.
আর কিছু বলেন তো আমি একটু অ্যাড করে দিই
তুই কোনটা অ্যাড করবি
Just যে বুঝলিস আমি আমার মতো একটা কিছু বলে ছেড়ে দিই
ঠিক আছে ঠিক বল মানে মিস্টার ভাই
What do you have to say about this arguing this 64 to the court is there cited?
but that is
Was it cited?
but to be very honest my lord we have not even not that we are not correctly recollecting but it is not cited my lord.
It was cited it was cited before the learned single judge where they have applied for
Everywhere where
they applied for before Justice Patnaik they have cited this for obtaining leave before puja they were arguing after my lord's order has been passed
my memory rightly
and my lord
Then second one is that
the second one they had said that in
second one.
the judgment rendered by the fourth judge bench of the
Samanta was there on that day. It is my submission. Samanta was there, and there Mr. Mitro was there. But but entire submission from their end. But when Lordship was dictating, going to dictate, nobody has any grievance or say that my lord something is still left over.
Very good.
Unlike today, that my lord I have to say this, I have to say that. If my memory recollects.
So,
And the third thing that I personally want to say, because this I can remember very well, 2015 5A, 2015 5 SCC 539. Well, I think that judgment had come from that side. And my lord, when this judgment we had considered both sides, my lord, after that, my lord, but there was no situation happened or took place that we want to deal with or we want to come on the other day, we want to deal with this.
Correct.
But no, they have specifically said it here.
they have taken the point
But they have not asked this.
Yes. They did not ask for any opportunity that was not given by your lordship.
And third
so
point.
audio alternate party was not denied.
The receiver has a full power to administer and preserve the property, which necessarily includes power to institute the suit or a legal proceedings. And therefore,
That
the
power has been
finding
granted.
that the appeal is not maintainable is per se invite the error apparent on the truth of the record.
The receiver is the so if the order that gives birth to a receiver,
No, can that be reopened at the time of review? Can this point be
that can't be.
I am making this question to myself. Can this then but the review that we have got
that
from
could have been a
CPC,
good ground for appeal? But
that's why I said
Can that be argued at the time of review?
it is not the situation that they are not, they are remediless but this review. Allegation I can take my as a high.
Next
For
The argument on merit has not been gone into by the appellate court.
What should I say? পাঁচ নম্বরটা পড়ুন।
The judgment relied
First should be prayed for. Then, suppose it is denied, then the cause arises.
Mr. Samanto has dismissed
Mr.
it.
Samanto, that's why most interestingly, Mr. Samanto is not there in these proceedings. Many a things court had Mr. Samanto been there, could have asked Mr. Samanto, the arguing counsel. That's why mysteriously Mr. Samanto is not there, interestingly.
Next point.
the learned judge who took up the
To it. Already squarely dealt to it, and no error apparent is there in the order. That is my answer.
Anything more?
From my desk, my lord, this he's for another part.
For the another
Response number 2.
few things, only, maybe some, maybe repetitive, but few things is that, first, on that day,
You are representing respondent
One.
for one.
one, I'm two.
You're true.
One thing, on that day, on that day,
কি বলছে এই কথাগুলো?
Appearing for respondent.
two. On that day, when took up this matter,
Once you appeared for the.
I have not, what has happened, Mr. Indranil Rai is a member of Ballarbi Club. He requested me to represent him. He sits in my table. We shared the same table, he sits just beside this next chair to me. He requested me that I have been appointed as a receiver. Kindly relieve me because I cannot take up that huge burden. A check that they have handed over, the applicant as a ad hoc 25,000. It was not given, the Indranil Rai wanted to pay it back to the applicant. I had to appear and continue with a check in hand that Indranil Rai wanted to hand over to them. By that reason, it has been recorded for the present receiver, Indranil Rai, who has been relieved.
Even
Yes.
can call Mr. Roy.
Mr. Roy is there in Ballarbi Club
For the purpose of.
returning the check.
Single correspondence from Mr. Gupta to
Now, a single correspondence, a single WhatsApp chat that you are
single
appearing
memo.
for me, a single memo from my side. Member of the bar, no memo arises, but in a single WhatsApp chat that this is my instruction to you. If they can show, I am out of I will not appear from the next day. Mr. Indranil Rai, I share the same table with Mr. Indranil Rai. May I come back to the merit? First, the issue of not giving a hearing is not at all taken into account because we now today have the opportunity of the live streaming. On that day the matter went like that. Today the entire tenure that it went up today for the entire second half. Mr. Samanto did not even he placed all the judgment he wanted to. The 64 judgment to my recollection was not placed. Yes, it was placed before Justice Patnaik single bench, where they had applied for a subsequent leave to represent the trust or to sue on behalf of the trust. That means they have acceded to the order. And kindly see the date of Justice Patnaik's order, it's of November. My lord's order is of 1st October. On that day, they even chose to suppress this order from the learned honorable single bench. We appeared and opposed the prayer that you have not annexed that order of Justice of the my lord's order. Then Justice Patnaik made a comment that you cannot choose an order and place before the court. On that score, they have handed over over the to the bench a copy of that order. When they file a GA 21, that means they have acceded to this order. Now they cannot come back when justice then they could not obtain an order on that day. If directions were passed, they cannot now come back before a lordship and seek a circuitous manner to seek a review. Now, coming back to my lord's order of Makhun Chandra Das and Lily Thomas, all are very apparent that there is to be apparent error on the face of the record. The ground that has been made out that they have not been able to cite some judgments, or they have cited, my lord has not recorded. I had the occasion to appear a division bench of Justice Dipankar Datta sitting with Justice Urjit Banerjee. The judgment was first started that judge's recollection is the best recollection. And I lost the review because Justice Banerjee recollected, because Justice Datta, Justice Jyotirmoy Bhattacharya was sitting with Justice Urjit Banerjee. Then Justice Datta was assigned with the matter. Justice Datta was not there. Justice Urjit Banerjee recorded with the first line that my recollection says that this submission was made. So judge's recollection is the best recollection. My lord cannot recollect. It cannot be a better can that they cannot make out a better can better case than. Now with regard to the review, they have only prayed for kindly take up any ground. For that this judgment could not be placed. For that this judgment that judgment could not be placed. Even the judgment which they have placed, they have not made out in the ground. Today some new judgments have been placed. Those are not in the ground. Be that as it may, and I leave it to Lordship for that. But the grounds that were being taken are not akin to the review jurisdiction. And what impugned order which they have come before the Lordship? The impugned order was that there was defalcation of funds. Justice Mojumdar, yes, they had entered for that reason.
Not want to go into this.
They have relied on the.
It's a reflection of what transpired.
Very well. They have relied on the subsequent orders. Now, subsequent order does not stretch the order of 9th of February. It haven't stretched the order. The 9th of February order is very much clear. Go and make inventory, file a report. He has filed a report. And they have annexed the report also to this review. His duty ends with filing a report. Now, on that day, when sitting in the appellate jurisdiction, was clear of the view.
We were considering the order which was passed, subsequently restraining them from dealing with any financial.
Absolutely.
That's all.
That's all.
So why we will go into.
Absolutely. And Milad was asking me about the 64th judgment. Paragraph 13 is clear. Well, if they are being granted with such authority. Now, February 9 order has not granted them that authority. Now they have prayed for before Justice Patnaik.
That we have already repeated.
So that is like that situation was not there on that day. And that's all, These are the judgments I am adopting,
I'm sorry that I was late. I was appearing for respondent number 3. My learned friends have argued the matter at length. But I do not want to regurgitate all those points which have been already taken. The only thing which perhaps bothers my conscience is, Lord, if your Lordship gives me permission for audience, I'll take only 5 minutes. There are 2 aspects to this review. Firstly, what I have understood of the brief, I could be wrong. I might require correction. But what has occurred to me is that this is an application foremost. First of all, my learned friends have gone in length that the grounds itself say they're attacking the order on the point of law. I have brought one judgment of the Supreme Court also. I'll place the latest one, where the review is not the ground, which is already fallen from my lords. The correct procedure perhaps is appeal. But why I am just taking your lordship's precious time is, I'm going to put this on test. That a receiver has the right to file suits, take out proceedings when it involves the mandate of his appointment. If the property is to be assuaged, saved from dissipation, if there are certain mandatory orders which are to be taken by the court, which issues out of his order of appointment, then he can come to court. But the question which I am putting to myself and repeatedly getting a negative answer is that, can the receiver have any audience before the court when an allegation is pointed to him? Because of the simple reason that I am submitting with it is that actually the brief.
He has a right of audience.
if there is any stigma, any allegation put on his functioning as a receiver, definitely the court will afford them an opportunity.
Of hearing in that sense. But the only thing, yes, that sense, yes, because everybody, if a finger is pointed, he has a right to defense, to clean himself, to purge himself.
He has to say whatever he perceived. That's all.
And
it's not going to depend for the parties or something like
anything like that. But only thing is that how far and no further. That is the question. Because there are judgments, my lord. Woodruff's book, your lordship knows more than me, cites certain old decisions of Indian appeal and things like that. The receiver, when he is attacked, he can represent, but he cannot argue his case in that sense, because his case is lying with the court. Today, that is why we come to court, to take leave to proceed against the receiver. Why? Because he is representing the court. His position is that high. Now, today, if his conduct in the litigation swings like a pendulum, that swinging of his conduct is something which the court will take very serious note of. Today, from the tenure of his drafting, what appears, my lord? Because we have to confine whatever high position, we have to confine to his draft. His pleadings, my lord, give smacks. It's not only that, I would only add on to your lord. It's smacks obviously goes with arbitrariness, thanks to our apex court. That's become a very celebrated jargon.
of the day.
I bow down, my lord, I bow down. But it certainly, it reeks of a very bad scent, of a very bad smell. If I may just take that liberty from your lordships. But he need not say.
Smack is not a, evoke is the appropriate word.
Evoke, yes, I would take evoke. Why not?
Smack, then something else.
I agree with your lordship, but I would still.
When you talk about the bad smell.
Yes.
Evoke,
yes, evoke. I agree. But once again, my lord, at the cost of repetition, but for the sake of emphasis, once again, I am beseeching your lordships to kindly consider this aspect, that can a receiver start firing so much when the court is protecting him? It is very difficult to steep allegations against a receiver unless our backs are to the wall. And we don't have any grievance against him being a brother in the profession. We have nothing. But it is our duty to assist your lordships to whatever extent your lordship permits us, to repeatedly hit on the point, to repeatedly bother your lordship at the cost of repetition, that, my lord, it is not in safe hands. At a religious trust, my learned friend is rendering very valuable assistance. I thank him for doing so. A religious trust. Today, my lord, I will make no bow. I will not have any qualms in admitting to your lordship that this is a building, number 10, one of the properties. There are so many properties, so many things to be done. But this property is infested by people like us. My lord, today I am facing difficulty. My lord, I will say the truth. What is my shame before the court? My lord, court is a place where my whole life exists. My whole life consists of that is decided. But the question is, in this review, my lord, kindly, six grounds, all of the grounds are appealable. My lord, kindly see, my lord, I am placing the case of Haridas Das. My lord, kindly allow me to place this judgment once. My lord, it's 2006 Supreme Court. My lord, maybe your lordship has already gone through this. My lord, I am just placing paragraph 13, only paragraph 13, if it helps. My lord, our intention is to save the, here. I will give my copy to my learned friend Debraj. My lord, I'll just read out and hand it over. The citation is 2006 4 SCC, page 78. I am placing for my lord's kind consideration paragraph 13. My lord, may I indicate?
Yes.
Paragraph 13. 13 is a very lucky number. It হচ্ছে এইটা 4 SCC.
This is 64 Supreme Court is cited.
Cited. Lord, all matters are here. A very crisp one. That is why I thought it might. Lord, may I read indicate 13 minute once? Not necessary. Lord, so this is one aspect. And then as for the other aspect, my lord, my learned friends have already dealt at length. I'm just pointing out for the sake of pointing it out only.
at ground number 10 and 11. 11 clearly says, from the division bench mistakenly or due to inadvertence or misconception of fact and law. Well, it is his own case, which is militating against him, my lord, for the maintenance of this application. My lord, it is law. Even law, there are other forums, my lord. Why review? And the Supreme Court, my lord, a caveat that you cannot hide an appeal in the guise of a review. That your lordship has said in the first hearing. I have taken note. So, my lord, these are the palpable reasons which stare at our faces. We are opposing tooth and nail, not against a brother, but his position. That, my lord, kindly, I am requesting your lordship with folded hands, my lord, kindly pave the way in which he can smoothly pass and we can have a new receiver. That is our intention, and I am laying it threadbare. That is pending, but will your lordship kindly take care of it, because your lordship is the highest court. Kindly, my lord, I am beseeching your lordship, my lord, that kindly take care of this when your lordship will pass the order, my lord, so that it is our easy task there. Kindly, my lord, take care of that. I am deeply obliged. I am deeply obliged.
Page 17 with reference to Mr. Nirmalo Dasgupta, my lord, that he appeared for the present receiver as well as for the.
That the court officer records.
That is a matter to be decided elsewhere. We are not.
But he is addressing on behalf of the before your lordship. But he is a conflict of interest.
Can you prevent him from appearing?
But it is a conflict of interest.
If there is any conflict of interest, then you have the avenue somewhere else. There is different law. I think he showed you no law.
Yes, but he cited.
Let them show one correspondence with Mr. Dasgupta.
But he submitted that.
That is what is different. He says that.
But record says is something else.
Individual person only for the purpose of handing over the check in terms of the order he appeared.
That's admission, my lord, but record says otherwise.
That is often done by Mr. Bhattacharya. Once they say he is for the receiver, was he say for the trust.
There are 20 orders.
20 orders are there.
Orders are registered against him.
Where is 20 orders?
So he appears for trust.
This day Ashok Gupta, this day for the trust.
There is no conflict of interest.
Oh, there is no.
Talking about, what are you talking about?
Just now we'll go and share the same table.
Cannot die.
He is raising this point personally.
More box. I'm not saying Pandora, but I'm opening a box for all of the members of the bar.
That.
For all the members of the bar.
But what happened, my lord?
Opening a box for that.
That's my lord's prerogative.
Not prerogative. When you raise, then I will deal with it. When you raise, I will deal with it.
Members of the party personally.
I'm shocked seeing this.
For all the members of the same.
We'll just go and share the same table.
Yes.
Members of the same fraternity. Member.
I have never not raised any personal aspersions on them.
I have objection, my lord. He has objected.
Every time.
This. That your lordship may record my submission, my lord.
Let them show one correspondence, single. He will go.
My lord, and that is also reflected from the order, my lord.
That he has given his back sheet engagement.
I am reminded of the famous story of Shankar Das Banerjee.
He submitted, my lord, with reference to the fact that I took out an application before the learned trial court pursuant to a lordship's order. My lord, we must abide by the law laid down by the court. My lord. There is no credit, my lord, in defying the order. My lord. If, my lord, we have the opportunity of approaching before this honorable court once again, my lord, it doesn't prevent us to follow your lordship's order, my lord. My lord, we don't want to project ourselves as an arrogant litigant. My lord. That's not our submission, my lord. We must follow it.
What are you talking? You are using a wrong word.
I don't. My lord, one more submission, my lord. They have Milord, I submitted, Milord, if, when there is an error apparent on the face of the record.
Proceed enough you have submitted.
Milord, second, Milord.
I tell you, if it is an error apparent on the face of the record, review, no doubt.
Yes, yes.
No disputes. I think they also cannot argue that the review is not permissible.
Yes,
Review is
Milord, they were
permissible.
making submissions today.
But the question is whether it invites an error apparent on the face of the record.
Yes, yes, that's so.
That's the only thing.
Exactly,
One has
Milord.
to find. If it is an error apparent on the face of the record, no problem.
My respectful submission is that
They say it is not an error apparent on the face of the record. You say it is an error apparent on the face of the record.
Then Lordship to
That
decide.
It is vested upon us to decide.
obliged to Lordship. There is, Milord, only, Milord,
আরে মানুষটাকে উঠতে দে
Considering,
সাহেবদের
your client,
মালপো এনেছো
Allegations have been made.
আরে বলেছে তো আরে
I'm a natural land of the first grade.
ও হিস
That is what I
when
have.
you are a litigant yourself, you should not appear wearing a gown. You should not wear the band.
Officer of the court, my lord.
বাবা
Receiver.
Dual
As an officer of the
The
court.
court.
Second and personal name.
Let us see what officer means.
Not officer of the court.
Yes, I have seen from the day one we joined the bar, what was the tradition of the Calcutta High Court when a receiver appears. Does he appear in full robe or he does not appear in full robe? Anyhow, we do not want to go
I
into
will
this,
abide by lordship.
but anyhow, this is not a practice. This is not a practice when a counsel is representing the litigant is arguing.
I'm not a
Every
litigant.
time they do that. I'm the receiver.
Then I will record that you are not a litigant, you are.
Again back to the square.
Yes, you are citing 64 as a litigant.
Your lordship has already passed an order.
You know, a person argues without understanding where he is.
See how abuses everybody. See how abuses.
Every time, everyday abuse.
Every time he abuses his other side.
Everyday abuse. We are abused every day.
We are abused here. We are abused with the single bench. Everywhere we are abused.
Disrupted and intercepted at the time of a judgment. Let the judgment be reserved. So that we can deliver it tomorrow. Dictate in the chamber and then bring up it again. Has to come again. So this is what I perceived from the may I say, the aura which I could feel from all the appearing counsel, that I will be intercepted. May not be
from
by
our side.
appearing,
Not at least.
but by one of the
Yes. That can
That
be.
is
But we
what I
keep
have
in
not
mind
done in my life.
better
I've got 40 years of.
that we are the officers.
what you are doing, but not since
আরে উঠতে দিন জজ সাহেবকে উঠতে দিন মিস্টার গুপ্তা প্লিজ এভরি টাইম
you are arguing, what does it convey?
উঠতে দিন
Sorry, Mr. Gupta.
এভরি ডে
Lot of leniency which has been given by the court because I feel the members of the bar are always at the very high level in my estimation.
মোর দ্য রিজন
I always respect this noble profession and I respect the person who holds this noble profession. And you are
and he remain as the officer of this court
do not inculcate
as a
any
receiver.
kind of a sense in us,
No, my lord.
which would tarnish the very high
I'm for the applicant, my lord. Three. I'm for the But there is a CAN restoration application.
What is the restoration?
CAN 11.
Number 3 is called.
CAN 11.
CAN 11.
CAN 11.
Have you, sir?
Yes.
Show us the affidavit of service, sir.
Affidavit of service has been filed on the last occasion when the matter was called on.
When it was dismissed for default.
30th of July 2024. It is at page 5. And
And you filed the application on 6th August.
yes.
So within time.
Within time. I missed the list when the matter was called. I am the advocate on record. I missed the list.
The application for restoration of the instant appeal, which was dismissed for default on 30th July 2024.
Well, in this appeal, well, filed by NTPC, well, I have filed an application, CAN 14. I, on behalf of the writ petitioner, respondent number 1 to 5.
Applications which are pending.
My lord. My lord, the last application.
On behalf of the respondent number 15 to 22, we have also filed an CAN application, CAN for 15. Well.
If you
Give me 10 first.
can.
Give me 10
For the respondent number 23.
সব applications গুলো বার করে দাও এক একটা পর এক এক পর।
CAN 10 to CAN 15.
তো applications গুলো দাও 10
My lord, CAN 10. CAN 10 was also filed by. ওই অ্যাপ্লিকেশন গুলো আগে নিচ্ছেন হ্যাঁ পর আগে 10টা নিচ্ছেন হ্যাঁ
ঠিক আছে 14 পরে 14 আর 15 এখানেও দাও
হ্যাঁ 14টা প্রসিডিয়ালি নিচ্ছে আপনি বসুন আপনি থাকুন 10টা দিয়েছেন? Can 10 was filed by the petitioner respondents, number one,
They wanted the compensatory benefits amount
my lord,
to the applicants 1 and 4
1 and 4,
for premature cessation of their employment.
yes.
School.
Well, the school was closed,
So respondent number 12 to give an undertaking.
my lord.
For who is the respondent number 12?
Lord, no,
The committee,
so number 12,
the college,
DAV College Managing Committee,
or DAY.
DAV College Managing Committee,
Type DAY.
my lord, this is my mistake, my lord. I understand.
So I just thought that's a day college. An undertaking to make the payments of the area salary
My lord.
in terms of the judgment under appeal. And also to deposit the differential amount of the Provident fund as per their higher revised scale.
My lord.
So
My lord, the school,
nothing remains in the appeal to be
my lord,
decided.
I am telling you, lordship, I am telling you,
What
lordship.
is the subject matter of appeal?
My lord, subject,
The subject matter of the appeal, if your lordship will kindly, the
The
prayer,
petition was filed what, for what?
writ petition, my lord, I am telling you, lordship. My lord.
kindly take this paper book, volume 1.
পেপার বুক আছে কিছু পেপার বুকটা দাও দেখি
May I please, your lordship?
এটাই তো
May I tell the just background of the can number 10, my lord, only.
It's not a background. First thing is that we have to look at the main cause of action which is there in the writ petition. And then for the appeal is filed, which is a continuation of a lesson. Suppose if the appellate court reversed the judgment of the trial court, then what would happen? If everything is done, then what would happen?
My lord, even then, my lord,
Page
I am telling you, lordship,
page
why?
36.
My lord,
36.
6, paper, volume 1.
So there was an agreement which is required to be void ab initio.
Yes. Then pair B is local managing committees.
Because the managing committee, that is the DAV, that was inducted as managing committee without constituting or forming the managing committee in accordance with the management rules.
That is what is the subject matter of the writ.
That is one part.
Has gone against you.
No, writ petition was allowed, but that prayer was not allowed. But the other prayer,
What the writ petition says, what it says, agreement to be void.
Agreement be void. One thing, if your lordship kindly next turns to page 38, where III, we ask the benefit of ROPA rules. Revision of pay allowance rules 1998 and 2009.
That has been allowed. This prayer has been allowed.
yes,
That is, my lord, where some dispute is there. The dispute is, my lord, by an order of in appeal in 2021, the school was directed to be closed because there were only 5 students for all the 10 classes. Total,
Remember when I was sitting in.
yes.
total number of 5 students in classes 1 to 10 in all sections, and number of teachers was much more. The court directed that yes, you are entitled to close down the school.
Exact wording was.
The question arose how they are to be paid their remuneration. There, my lord, the appeal court directed that you pay as per your calculation, pay 50% of as per your calculation. We had paid 1 crore or something like that to the concerned teachers. There were only 5 writ petitioners. Only 5 writ petitioners.
Only 5?
Only 5 writ petitioners. Not all the teachers and non-teaching staff. Only 5 writ petitioners.
Now, we paid them this. We paid them according to 1998 ROPA, but not 2009 ROPA. By subsequent orders, we paid as per 2009 ROPA also. And in an earlier order of the Honorable Division Bench, presided by Justice Shomensen, there was a direction that instead of from a particular year, why not give from prior 2 years also? Consider it through your board of directors. The board of directors considered it, allowed it. Therefore, these were paid from 2009, the arrears, etc., all was paid like that. The petition was filed in a year. Prior to 3 years, we had paid, because there is Supreme Court judgment which says, the monetary claim with regard to employment also, the limitation is 3 years. We cited that judgment. Court said, all right, 3 years you have paid. Why not consider giving them for 2 more years? Then that was also paid. And 2009 ROPA scale was given. Then, certain other persons started coming in to be added as parties. Those were some teaching staff who were approved staff of the school. With regard to them, court directed make payment to them also. Add them as parties, make payment to them. We have paid them. Another group of persons have come who are primary teachers. Some unapproved teachers in the secondary section, and some primary teachers in the primary section. Unapproved staff is also there. Now, regarding payments to them, we have made payments. We have in our affidavit, we have pointed out. When your lordship will be taking up the next applications, we shall point out. Now, the primary teachers, they do not come under because this is all relating to the recognized school recognition given by the Board of Secondary Education West Bengal. Primary department is not at all coming under that. Therefore, we said, regarding primary teachers, we don't take any responsibility. And there is a division bench judgment in a previous proceeding where the court held that the NTPC is not the employer in relation to them. But even then, we said that we will make payment. We will not make payment directly to them. We shall deposit it in court, and the court and let them withdraw it from the court, like that. Sorry, local managing committee, not the court. Local managing committee, because that was prevailing then, because after the closure of the school, there is no local managing committee even today. Therefore, if anything is required to be paid, we will have to pay through the court. That's the position. But our stand is that we have paid entire thing.
Why you agree?
I am not aggrieved anymore.
You are the appellant.
I am the appellant. They are making applications one after the other.
Why the appellant? Why you have come up? For what reason?
No, all these proceedings took place in the appeal. All these orders I referred to, these are all orders.
What was the
Our
judgment
simple
of the single bench?
Single bench was
That
judgment.
I have taken to a writ petition
Hmm.
where several prayers are made. So what the
The
single
judgment
bench
about
states
single.
is 36. First, there is declaration of the agreement to be void. Has it been declared as void?
No. No. 443 volume. Third volume.
Second volume ta din to
443 is in the second volume. Because the judgment starts at page 453. 483 আমার দেখা যাচ্ছে কত বললে 481 If your lordships kindly come to 483, this is the operative part of the judgment, paragraph 40 of the judgment. At page 483,
yes.
I place this. In the facts and circumstances aforesaid, the review application is allowed. This court directs NTPC to fully comply with the undertaking given to the Director of School Education, Government of West Bengal on 2nd November 1987, and to act fully following the conditions given by WBSE, West Bengal Board of Secondary Education, in its recognition letter dated 11/5/1989, which was accepted by NTPC, which recognition is still being used by NTPC and DAV. Now, what was that condition given in the recognition? That the payment of salary to the staff, teaching and non-teaching staff, shall be as per the government norms. I further direct
The 2nd
NTPC.
November 1987.
Yes, sir.
That is the 2nd November.
Yes, yes. 1989. Recognition letter dated 1/10/1989. I shall cite a judgment of the Honorable Supreme Court where the court has held that for schools which do not accept aid from the state, they are not required to pay at the government rate, even in spite of the fact that in the recognition letter there is a condition.
Okay. Then further direct NTPC.
I further direct NTPC to pay the salary and allowances to the petitioners in terms of Rupa 98 with all consequential benefits arising therefrom, and also Rupa 2009 with all consequential benefits arising therefrom from December 1, 2018, and to pay arrear pay and allowances which was required to be paid to the petitioners from the date when the pay and allowance equal to the salaries of the assistant teachers of non-government schools was stopped, with interest at the rate of 8% on the total arrear amount from that day till date of payment. Such arrear salary allowance be paid within a period of 3 months. Paragraph 41. In the affidavit in opposition of both NTPC and DAV, I have found that they have tried to take advantage of the order passed in WP number of 1998 on August 13, 2000, and deny the pay scale and allowances of the petitioners as was required to be paid to them as per undertaking. The conditions, again mirror that undertaking. The conditions imposed by WBSE and the advertisement issued by NTPC for recruitment. NTPC and DAV has tried to cover its illegal acts by denying the above pay scale to the petitioners by using the said order 8th August 2000, being totally oblivious that no order of a court, let alone order of a writ court, give liberty to any parties to act illegally using the order. As retirement benefits are a consequence of qualified service of an employee, NTPC is also directed to pay retirement benefits. Then 43. NTPC is directed to pay cost to each of the petitioners amount of 20,000 rupees.
So it was not declared to be void.
No.
Agreement was not declared to be void because corresponding obligation of NTPC and the DAV was recognized in paragraph 41.
Yes.
So the first prayer was actually denied. The second was also denied.
Yes. The arrangement be declared illegal, that is also denied.
So they have not been declared. The respondent is to appoint administrator is also denied.
Yes. That is then kindly turn over to C2.
C2 is also denied.
C2 is denied, but C3.
C3 has been allowed.
Yes. C3 has been allowed.
1998 and 2009. So this has been
C3,
allowed.
C3 and C4
And C4 is
allowed. 98 and 2009.
2009 allowed.
C3, C4 allowed. Same thing. 3 and 4 allowed.
D is immaterial.
D is immaterial. Then statutory.
Immaterial.
Yeah, that is immaterial.
An
Therefore,
interim order does not arise because it was finally disposed. So these are the things.
yes,
which are
at
there.
page 38.
And your grievance is that even if a condition is imposed at the time of recognizing the school or giving recognition by the West Bengal Board of Secondary Education, these the condition relating to the payment of salaries and all everything when the school is not getting any aid
That's it.
is farcical approach.
Is farcical approach, and the liability will be fastened only if there is a statute in place. That's what the Supreme Court has said. Now, the second contention of mine is this.
So you are really assailing this particular order. Now, in the perspective of the fact that this relief has been granted, let us see at 10 first whether at this stage the prayer has made can be given. According to you, that during the pendency of the instant appeal, you have in fact made the payments.
Yes.
As per 2000 ROPA to
98 and 2009. Yes.
50%.
No,
Full.
thereafter full.
Full. So you have already made a full payment.
2009 you have also paid.
Yes.
Yes.
also paid.
Now, so far as certain retirement benefits are concerned, because they wanted 1 and 4, the premature cessation of their employment, compensatory benefit. So what compensation can be provided to them has to be decided.
Yes. Now, Miller, on that, before directly approaching this issue, let me submit one thing. Miller, I had cited a judgment possibly before your lordships also, when Justice Tandon was sitting in a different composition, that there is a Supreme Court judgment which says that there is the period of 3-year limitation applies even to such cases. Therefore, Miller, we restricted our payment to 3 years.
No, that is the other aspect. So far as extending the benefit of ROPA.
No, extending not ROPA only. Miller, that is by way of a compensation. That is what I say.
So if you say that you actually is entitled to restrict it 3 years before the institution.
Yes.
But out of your benevolent action, you have extended 5 years actually.
Miller, I will not only say benevolent, I will further add, Miller, that they have lost their employment. Therefore, this is a compensation for that.
So 2 years.
2 years, additional 2 years.
So then what remains at this stage?
So what about paragraph 2? Arrears salary, according to you have already disbursed.
Yes, I have disbursed. Arrears salary I have, as I said, Miller, I restricted it to 3 years, then Miller extended it for 5 years.
What remains there?
My lord, according to my learned friend's statement, that they have.
My lord, I have filed 2 affidavits. Would your lordship kindly produce this, Miller, before asking my learned friend? No, regarding this application number 10, that possibly doesn't survive anymore, because subsequently 14 and 15 they have filed.
True. That's why I'm just really wanting to know, because
Yes,
we are taking one after another.
Lordship.
Let me see that what remains.
My lord, my lord, reserve my argument for or in respect of the submissions made in respect of the appeal itself on merit.
I am not on appeal. Sir.
I am on section 10. Section 10. Yes, can 10.
Taking application in seriatim.
Yes, can 10.
About can 10.
Can 10 is yours application?
My application.
There are 2
My lord,
applications.
can 10 application is, my lord, filed by me because there was an order granting liberty to the.
Whether it survives or it does not survive.
It survives. It survives.
For what?
Because, my lord.
Then we will give them an opportunity to file affidavit.
They have filed, already filed.
Oh, in 10 they have
10 filed. Affidavit reply complete. Complete.
Yes.
Complete. My lord, can 10, my lord.
Have you given a reply?
Yes. My lord, can 10 was filed.
September 2021.
2021.
Quarter has flown there.
Yes.
All payments are made after that.
I tell you, Lordship, my lord, the can 10 was filed. On the teeth there,
your payment is restricted to up to 3 years, 3 plus 2 or 5 years.
3 plus
2 years prior to the institution of the proceeding.
My lord.
Only one thing, yes, I mean, that I appear on behalf of the respondents number 15 to 22. Now we have been added on 20.
You have been added?
Yes, we have been added on
in appeal.
24th of March 2021 by a division bench of this court.
But your cost title does not show. It ends with the.
That I can, Miller, what is there on record, Miller?
They have been added in the appeal itself.
You are.
Now, Miller, we are respondents number 15 to 22.
Who are you?
We have made 2 applications. This is
you.
Now we are Miller, yes. If your lordship Miller ask me, Miller,
you are a primary school teacher. You are
we are the employees of the NTPC High School. We are employees of NTPC High School.
In any section?
Miller.
Primary section or a secondary section?
Some are primary, some are secondary.
Approved or unapproved.
Now those documents which are
will take care of yours.
My lord, section.
Take care of his
yes.
problem.
I
by one will take care of.
Can number 10 was filed. When, my lord, prior to that, an order was passed granting liberty to the NTPC appellant to close the school, not directing. Granting liberty to close the school in peculiar circumstances of reduction in the number of students' strength. My lord, we, my lord, apprehended that by reason of the closing of the school was actually closed on 21st of September 2021. Or 30th September, sorry, 30th September 2021. My lord, consequent upon the closure of the school, there will be no managing committee. There will be no existence of the school. Therefore, we the two writ petitioners, number 1 and 4, my lord, were still in service.
Quite the year 2014.
Writ petition was filed. Yes. My lord, the writ petitioners.
There was no closure.
No closure. There was no, my lord, the issue of closing the school was not, neither the scope.
Let us understand. That was delivered in the year 2018.
18.
Judgment was delivered in the year 2018.
Therefore, my lord, what I was submitting.
Application on 1st September 2021.
Yes. Therefore, my lord.
When this judgment was already there was no stay which was granted to you.
No.
No. So this is how it happens. Now you have filed this application. You wanted compensatory benefit.
Yes.
2, 1 and 2 for premature cessation.
Yes.
Means you have been prematurely put out of employment.
Yes, ma'am.
Great. So they say that for that reason we have given you 2 years extra amount.
No, not that. I tell my lord, I'm telling you, lordship, my lord, these compensatory benefit is totally independent of the area salary to be paid in terms of the judgment of the.
Not said. They have said that when you ask for a compensatory benefit,
yes,
then the compensatory benefit being a monetary relief,
yes,
cannot be claimed beyond the period of limitation of 3 years. So on the day when proceeding was initiated, 3 years backlog, it get claimed. But since there was certain mandates, I would say the observation of the division bench, they have of their own have also given 2 years of compensatory benefit to you apart from 3 years. Means 3 years benefit has been given with the current one.
That part I will, my lord. That part, my lord. That part I will, my lord, argue before your lordship at the time of hearing of the appeal itself. But now, my lord, I am telling your lordship, compensator. Yes. My lord, your lordship, kindly. No, my lord, your lordship, I have not gone.
So initially,
my lord, your lordship, kindly consider my submission.
The application can be decided in isolation.
My lord, may I, before starting with the can 11, my lord, may I say something on can 10? If you lordship kindly.
Because you are really arguing on the merit.
No, I'm not.
You are arguing. You say that these are the merits of the appeal, which has.
No, I'm not.
So,
I'm not.
Observation at the interlocutor.
My lord, kindly allow me for just for a moment, my lord, just for a moment. My lord, compensatory.
Whether these can be termed as a compensatory benefits.
Compensatory. My lord, I'm telling you, just for a minute, my lord, kindly bear me for a moment. Compensatory benefit is relatable to the period of my remaining service.
For which appeal is required to be adjudicated.
To be gone into the appeal.
After 30th September 2021.
Gone into the appeal.
So that
Let them argue. They have not argued their appeal. We have not applied. Suppose if we say that the entire judgment.
That is my whole contention, that the compensatory benefit.
If we hold, ultimately we don't know that this judgment cannot stand. If we set aside the judgment, then what will happen?
My lord,
no compensation. So it's better to decide. the mark.
That is why I was arguing, my Lord, your Lordship, that this
Don't know which
compensatory,
way they will argue.
no, compensatory benefit is not relatable to the, my Lord, arrear payment. Is not at all relatable to the, my Lord, because it was not within the scope of
22.
22.
My Lord, probably, my Lord, I could not make myself clear, my Lord. My Lord, because it is,
To make, conserve your energy, argue when we fix the appeal. Don't worry.
my Lord,
We'll hear you patiently.
this is the relating to the period after closure of the school.
Can we decide it now?
My-
It is a matter which is one of the point in the appeal itself.
No.
No.
My lord, as a matter of
Some
fact,
orders have been passed, some compliance have been made.
All
We will
kinds
not
of-
take into account the subsequent events. Will we not? Do we not, because they have paid, do we not take into account and consider whether that is, any further thing is required to be paid or not?
That is why I was saying that
That
it
is
is
what I'm
totally
saying, that
independent.
interlocutory-
That is why I was arguing, my Lord, this is totally independent of the arrear payment.
No, it is in terms of the order passed in the instant appeal.
No, my Lord, it is, my Lord, because of the, because
Can you segregate the cause of action in the appeal? I have not learned the law like this.
my Lord,
If an interlocutory order is passed, and if there has been a compliance of those interlocutory orders, the court will definitely take into account those subsequent events while deciding the appeal and can definitely mold the relief.
well,
What are you talking about?
no, it was on,
Independent.
let us not waste your
If
valuable
the
time.
appeal is ultimately allowed, then all these orders will go. Then you'll have to, revert back to the situation. Will not court take into account that what benefit you derive from the interlocutory order should be taken away? So it has to be heard along with the appeal. Don't worry. What is this?
Now, my lord, I have taken out two application.
No, this is.
No, no,
Application
Cat 11.
11. Yes.
Who has taken out?
Now, my lord, I have taken out this application. Now, my lord, the reason for taking out the
There
kindly
are 8 applicants.
page 29.
8 applicants.
Yes, there are eight applicants.
Why the order dated such and such passed by the TIC? Oh, this is the order of termination.
Yes,
What is
that's the reason I am showing to my lords page 29. 29 and 30.
Identical orders.
Yes, yes, yes. Yes, my lord. Now, my lord, my respectful submission before my lords is that, my lord, so far as the matter is concerned, this particular order should be stayed, and my lord, the submission which has been made that some payments have been given, we have not been given any payments till date. No money, nothing.
Does it not invite a fresh cause of action to be gone into?
No, my lord, your lordship may kindly consider.
The managing committee?
My lord, your lordship may kindly consider that these are persons who have come with the last hope of their life. With the last hope of their life before my lords. They cannot even, my lord, not earn. They cannot afford their minimum expense for their children for education. They cannot sustain. They are standing in the court. They come every day looking at the, my lord, looking at the particular, my lord, fate of the litigation. Nothing more. আমাদের কত And my lord, one thing more, I can make a submission before my lord, subject to kind sanction. That, my lord, these particular persons, they were not given the benefit of ROPA. And my lord, the other thing which I would be indicating before my lords is that the
Parties to the writ
we were,
petition.
Milord,
You have been added.
You are not.
we have been
parties to the
added.
writ petition.
Milord,
They have been added in the appeal.
পরে তাহলে ওইটাতে পাঠিয়ে দেবে। Milord, on instructions, I should also indicate before my lords that on instructions that a separate writ petition had been filed by these persons. Otherwise, a situation may come that we are not giving anything to anybody, and therefore, but virtually, Milord, your lordship may, I can appeal to my lords that your lordship may kindly take a very sympathetic view so far.
I'm putting a.
I know that, I know what will be the answers of my lords. My lords have laid down the law that benedictions impelled with sympathetic consideration cannot be the subject matter of an equity jurisdiction. Therefore, I am not.
I am on another. You have already assessed this order. The writ petition is pending.
Yes.
Suppose if this application is allowed.
No,
Virtually negate the writ
not assailing this order. Not assailing this order.
order of termination.
Milord, I should, Milord,
Order of
I should come up with that writ petition because it would not be proper on my part, Milord, to make a submission.
You'll have to show that whether you have
তুই আমাকে
also
দেখা যে কি
challenged the order
petition
of
করেছিস।
termination.
তুই আমাকে রিট পিটিশনে কি সাবজেক্ট ম্যাটার দেখা। তাহলে এটা যদি করে থাকিস তাহলে ওখানে যেটা হবে সেটাই তো ওখানে হবে।
কিন্তু আমরা তো ওইটা প্যারোটি চেয়েছি দেওয়ার পরে আবার এটাকে সাবমিশন অফ
Milord, what has happened, Milord, I find, though I have not gone through the writ petition, that I should make my stand very clear. Prayer, Milord, to appoint administrator, Milord, before that, Milord, declaration that the agreement between NTPC and its FARACA, same prayer.
Next.
And that's the reason, Milord, I say, Milord, that even the termination of the order also, I find, Milord, that has been challenged. That has been challenged. That I should say.
Administrator in respect of a non-existing school. Close. That is what.
I'm talking about whether the order of termination, which is sought to be assigned here.
Milord, termination is a normal consequence of the.
If it is a subject matter of challenge, then there are two courts open. It should not decide it because it will impact this writ petition to be decided. Once the division bench has observed either the termination is good or termination is bad.
I will lose all my forums till the division bench.
The better that we should relegate them to the writ where they are going and let the writ be decided so that they may not lose the forum.
Yes.
First. Second option is a discretion of the Chief Justice. If
he is there,
here in the
Provided
then everyone will be safe.
Provided they file one.
I do not know.
They have not filed.
So they have filed a writ.
No, I can read file which.
Selling this order, which they are selling by way of an application.
WP number 17355 of 2021.
Reply company keep जैसे अगर assign करते बोले
Oh, Mr. Mukherjee is now aging. He's pending. That's why we are making this observation. Had it been disposed of,
Milord, may I ask a question? Milord, may I ask a question? Extra legal matter. Do not take me amiss. Who is aging? I am aging. But my lord is saying that Mr. Mukherjee is aging.
because he's not realizing the core issue.
No, he is not aging.
Only I am maintaining status quo regarding age.
That's the only way in this application. We can't go into this aspect.
I'm grateful to my lord.
Although
You can't.
I can, yes, yes.
expand the
Well,
horizon of
me,
the field.
my lord, may I then do one thing, subject to kind sanction of my lord. My lord, may a letter may kindly be made by my learned junior before the before the secretary.
This is an application at the PS top being added respond. Because it is pending. It is showing pending in
আচ্ছা আচ্ছা দেখাচ্ছে 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 তো করছে তো
ডিসপোজ অফ হয়ে গেছে বলছে।
যে অর্ডার শিটে দেখলেই বুঝতে পারা যাবে অর্ডার বুকটা দেখুন না না এটা
Where is the disposal? No.
দেখুন না এটা 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 হচ্ছে বারোই ফেব্রুয়ারি 2024-এর আজকে অর্ডারগুলো দেখতে হবে। 14টা দেখো তো 14
No, Mr.
এখানে দেখি
It has not been disposed of.
Mr. Gupta, it was affirmed on 12th February 2024. So it should have been disposed of after that date. 12th February, দেখুন তো। হ্যাঁ হ্যাঁ 12 একবার দেখে নিচ্ছি হ্যাঁ 12/2 ভালো করে check করুন।
So, Mr.
no,
It does not appear that it has been recorded to it is recorded as disposed till. Yes.
Mr. Gupta,
2009
first class হয়ে গেছে এই বলছেন দিয়ে দিয়েছে সুতরাং এটা আর কেন দেবে
So this has already been done. So should we record?
disposal.
Yes,
Look,
it has
I
become
find, my lord,
infructuous, we find.
an order dated 30th of September 2024,
30th
September 2024, passed by your lordships with this composition of the bench. From there, it appears that it is pending.
Yes. No, Mr. Gupta, kindly see the prayer. Prayer of Can 12. Has it not been?
You have taken a decision, board.
Yes.
Show us the decision. Show us the decision of the board so that we can record it.
Order sheet को दो, order sheet.
Yes.
हाँ मुश्किल है
সামনে আছে
order আছে order sheet.
বলেছি
order sheet এখানেই আছে order আছে একটা পাচ্ছি
তারপরে
if your lordships kindly take the order dated 21st of March 2024.
10টা ধরেছে 10টা বলে একটা টাইম অফ অ্যাপিল হিয়ারিং
21st March 2024, where the resolution of the board
দেখছে 12টা আমাদের না
is quoted.
হ্যাঁ 12 আর 13 দেখছে এটা হচ্ছে চতুর্থ কি সেটা কেন করেছিল ওই board of
Oh, virtually record taken into account, but it was not recorded at disposal.
হয়ে গেছে
Recorded. This is an application at the
Yours.
Whose application?
Kumar.
Modifying and varying the order of 5th December.
Directly in order to exclude the expense benefits.
What has been done? We can't take up this matter.
No.
This
This
is
is
order
filed
of
by
5th
whom?
December, not passed by us.
No, your lordship may simply record that this has been
For the
complied with.
applicant, sir.
Yes.
This has been complied with. This has been complied with. It says that instead of 26, 20,
অন্য লোক করেছে
ও?
কিন্তু এটা
হ্যাঁ?
অন্য অ্যাপ্লিকেন্ট এরা
ও
reputation
আচ্ছা,
আসার জন্য
petitioner নয়, added parties.
হ্যাঁ এটা ওরা খালি 5-7 জন added party হয়ে agree করেছে
এটা অন্য লোক।
অন্য লোক
দেখুন এরা আলাদা লোক আছে প্রাইভেট লোক।
নবকুমার।
হ্যাঁ
No, this is an application by an applicant, one Kumar Das and Subhash Chandra Mandal.
এই NTPC কে বলছে এক্সপ্লোর করার জন্য।
Pradeep Kumar Ghosh.
They are also added party. They have also been added.
No, who is representing them?
Mr. Oyan Banerjee.
Oh,
approved এরা
where is he?
কেউ দেখুন আমাদের দেখুন that we explore the extending similar benefits এত
ওরা যদি দিয়ে থাকে
12 আর 15 রিটায়ার করে গেছে।
Copy was served on us, my lord.
What is your, have you filed your opposition? Have you disclosed? Why they cannot be given the same benefit?
No, there is no opposition. There is no opposition filed to this application.
They are claiming.
Yes, they are claiming the same benefits.
Same benefits.
They retired in 2012 and 2015. Therefore, they are asking for 2009 benefits, 2009 Ropa benefits.
Yes. So what can be done? Will you take instruction or what?
এরা যদি পায় আমি একটু
Of extending the same benefit?
আমাদের যে বেনিফিটটা দিতে চাইছিল সেটা
এদেরকে দেওয়া
ওরাও
হয়নি?
সেই বেনিফিটটা চেয়েছিল এই অ্যাপ্লিকেশন
দিয়েছি তো petition ছাড়া।
ওদের ব্যাপার
এই benefitটা আমাদের তো করতে হবে। will be hard করে দেওয়া হবে।
হ্যাঁ।
তাহলে এইটাও তাই অর্ডার হবে।
Yes.
Instruction নেবো।
Subject to lordship's correction, probably, my lord. This should also, my lord,
We
same.
need not do like Can 30. There is
My
no
lord,
clearance on behalf of the applicants. However, the Mr. Gupta, the learned senior counsel representing the
NTPC.
NTPC Limited, submits that the prayer made therein cannot be granted unless a specific instruction is received from his client. So in view of the above, let this application be listed. We have adjourned for a week after
এই এক সপ্তাহের মধ্যে।
এটা can 30
Appointing हो रहा है.
Yes, my lord. 14. This is our application, my lord. I am led by Mr. Ben.
Point option form for each of the applicants in the web portal of EPFO authority. They wanted to withdraw.
No.
Can you stand in the way? No.
No. Withdraw.
Yes?
Withdraw.
Why?
NTPC can't do that.
Joint option form
Has to be signed by
Joint option for,
by all of them.
joint option for,
EPFO authority.
yes.
Petitioner respondent's application, our application.
Oh, joint option.
How they are involved in this?
My lord, the joint.
Because Miller NTPC,
Here,
NTPC lawyer কে আছে?
Provident Fund.
My lord,
That's why
Oh, Mr. Gupta is the NTPC lawyer, learned advocate for a NTPC lawyer.
that's all right.
Against
But
whom?
the prayer be
Against whom, my lord, we made a claim.
One where I do not know. What is the Employees Provident Fund?
that is
Separate
that is
I
that's
think it's
separate
separate
organization.
body.
under the Employees Provident Fund and
Act.
Miscellaneous Provisions Act.
So this is the body who maintains it.
Regional Provident Fund Commissioner.
And here they say add him as a party and then give this.
No, that is,
Yes, that's prayer be.
let me place my case.
We
How-
cannot get our pension and other things, other
So it's not a pension, it is a provident fund.
It has been given and
আপনি বলুন, আপনি
pursuant to that, there is also Miller, your lordship may kindly come in my application, para
ওটা
A.
কার application?
ওরা 15 বলছে, ওরা 15 বলছে। আমাদেরটা আপনি বলুন।
দাঁড়াও না।
I am in 15. I am in 15. Not
Lord, this is my read petitioner's application. Lord, Lordship kindly come to, Lord, as per rule, my Lord, 11(4) of the Provident Fund rules.
Oh, the regional provident fund commissioner be added as a party. So they have not been added as a party.
This is not extending the scope of the appeal.
No, this is wholly, my Lord, not extending the scope of the appeal.
Now I have an advantage of Mr. Banerjee appearing in this matter. Yes, what is the concept of a necessary party and a proper party? I think I have a privilege. of
Lordship
asking
knows,
you
well. Lordship knows, my Lord, necessary party. Lord, your Lordship knows.
No, then you are moving this application, tell me.
Yes, therefore, my Lord, I may place before your Lordship, first of all, my Lord, the question is, my Lord, in this case, that Provident Fund that was already given in terms of the interim order passed by this court. Kindly come to the interim order first. Lord, my grievance, I may place before your Lordship my grievance. Lord, page 17. Lordship, kindly come to page 17. Only proper. Lord, page 17. Lordship, kindly come to page 17. Lord, the Lord, authority, Lord, page 19, Lord, operative part.
What was the scope of the writ petition? And what was the scope of an appeal?
Lord, a scope of an appeal is, Lord, that the main relief, Lord, we got from the read court, Lord, is that we are the employee of NTPC and we are entitled to have the, Lord, Provident Fund also amount. Lord, that order was also passed by the read court. Now, Lord, on the basis of that order, Lord, they preferred an appeal, undoubtedly. Now, Lord, during the pendency, the order passed in read petition was not a state. Operation of the order is still in force. Still in force.
Tell me their obligation under this.
Now, Lord, by virtue of the interim order, Lordship, kindly look to the interim order first. Paragraph below, page 18. Since the school may close down immediately after conclusion of the higher secondary examination, the appellant NTPC Limited will act on behalf of the school with the higher secondary board and other authorities for the purpose of obtaining mark sheet, certificate, etc. and all other matters of examinees, and will take responsibility of handing over the documents to the students. The appellant will ensure that before the closure of the school, all documents which the students are entitled to, for example, a school leaving certificate, character,
With the student.
with regard to the students. Then,
You are reading, Mr. Banerjee, you are reading which paragraph?
Lord, page 18, my Lord, towards the middle. But, Lord, it is with regard to the students. Let me come to page 19. Lord, towards the middle.
19 of your application?
19 of my application.
14.
And 14. We direct the 50% of the area part of the package be paid by NTPC Limited to the 5 respondents by 31st of March 2021. The balance, now, Lord, when the amount,
So it's a package.
yes, then
What
balance,
is package?
may I, yes. The balance shall be paid at and before closure of the school. Let such payment be made by NTPC without prejudice to the rights and contentions of the respondent in this appeal. Now, my Lord, they, at the time of payment of the amount, my Lord, by 2 installments that have been granted by the interim order. Lord, they have deducted Provident Fund money, Provident Fund amount on the employer side.
Page 21.
Lord, therefore,
Page 21.
Lord, your Lordship, kindly come to page 21. Lord, these are the documents from which the deduction of the Provident Fund, Lord, has been made at the time of payment of that. Now, Lord, according to Rule 11, subject to decision in the appeal, according to Rule, my Lord, under Section 11, subsection 4, the enhancement of the pension shall be made, provided the joint Lord signature with the joint signature, the Provident Fund form must be submitted before the authority, Provident Fund authority, by 31st of January. And they refused. They are not supplying this. Before that, we have submitted before the authority. Now, Lord, in the event that is filed, Lord, subject to the decision of this appeal, in the event, my Lord, appeal court holds no, trial court order is right, then we are entitled to have the enhancement of the pension. But, my Lord, because of 31st is gone, and therefore, because this is their activities, for that reasons, my Lord, we could not be able to, they did not forward that copy. Now, Lord, your Lordship, kindly come to that. Message, page 46, my Lord. Page 46, message. For pension or higher wages. Lord, because Lord, the school is closed down. For which, my Lord, some of the
That was sent by EPF authority.
Lord, EPF authority, my Lord, send these messages to us.
In the registered mobile number?
In the registered mobile number.
Account holders.
Account holder in the registered mobile number, my Lord, it was sent. We take out that copy.
Mode of sending.
By message. This is the message. It is printed.
It is a message, my Lord.
Mr. Banerjee, why you people are so much?
Lord, it is a message, my Lord. It was given to a registered mobile. We accordingly, my Lord, transferred it to the computer and take.
Modes of message being given to a registered mobile holder. I am just asking, what is that? What is this?
Lord, this is the message sent by the authority.
Message can be sent multiple way.
Yes, this has been done. Lord, in the mobile number. In the mobile, this has been the message.
Sent to the mobile number. Messages are sent to the mobile number.
Mobile number.
In what manner?
In which application?
Electronic.
Lord, electronic records, my Lord.
Electronic, that means through email.
Through email.
Message box. Does not show
Message box. No, this is not email, my Lord. This is a message box. It has come from message box.
Message box has multiple applications as a message box.
But this has come. And my Lord,
also have a message box in Truecaller. You will also have a message box in many other apps. Which is that?
কোথায় এসেছে এটা? Truecaller এসেছে।
No, registered mobile number. Yes.
Mr. Banerjee, you are relying, tell me.
Lord, it has come, Lord, in the registered mobile number. Message has come from these are the messages, page 46.
What is this message?
Message, my Lord, is your application for pension on higher wages.
It's a message in the Instagram, it is a message in the Facebook, or it is a message in the WhatsApp, it is a message in the what?
Lord, it is a message directly on a registered mobile. It may be in the Truecaller, it may be in the Truecaller, or it may be in the, my Lord, other app. But directly in a registered mobile.
If you have a WhatsApp, it's a registered number which is there, registered with a WhatsApp.
WhatsApp number also. Lord, in the WhatsApp, sometimes, Lord, in the WhatsApp, my Lord, messages are coming.
Registered
In the Truecaller, my Lord, messages are coming. Lord, in the registered mobile direct message box, my Lord,
is?
It is in the message box.
The WhatsApp or it is?
It is message box, my lord, message box. That is SMS, my lord, short message box, SMS.
They like that.
Yes, that is your lordship. Right. It is SMS.
What is the full form of SMS?
Short message service. Short
Message service. Short message service. We have to know everything, my lord. We have to know that every day. We are always, my lord, searching the law.
Who means the Provident Fund or the pension fund?
And your lordship kindly come to
The Provident Fund, that's why I'm talking about Provident Fund or a pension?
Pension under.
pension.
The employees pension scheme 1995.
Right.
First done by 11/4.
But this has now been
Pension
closed
scheme.
by reason of the Supreme Court judge.
What Supreme Court judgment?
That if the employer and employee agree to a contribution of a higher amount, depending on the actual salary and not the city, there would have been a cut off. The basis of an amendment was being considered by the Honorable Supreme Court. It went from Rajasthan High Court. The Rajasthan High Court declared that
Kerala.
provision.
No, Kerala High Court. I have brought it, my lord. Supreme Court judgment, yes.
2 years. 2 years. 2 years.
Due to yes, Kerala and Rajasthan both, yes. Yes, my lord. Yes, right.
Of the amendment was upheld by the Honorable Supreme Court. The window that 6 months time period is granted to the central government to re-legislate. And the employee will not have to contribute extra.
So what is this? This
This is how we go long time back.
No. Article 1:1.
Extended, time extended.
Amount which is lying with them, what is to be done?
Provident Fund is lying with the Provident Fund Authority. Pension will also be disbursed by the Provident Fund Authority.
They have to join the option.
Not by the employee.
That you have to give a duly filled up countersigning of the amount.
That was for higher pension. That higher pension.
Yes, why they are disputing?
Legally payable. There is a form 10C which the employee has to fill up, and he can do it through the bank manager, he can do it through the member of the legislative assembly, member of the parliament, or easy.
Employer. It is employers.
Amount which is now lying with them, they can withdraw.
That will be a, that
No,
if you come to the message box of the employee concerned, he will get it from there.
No, not paid for two.
We are not doing the amount.
For pension,
Lord, we are not withdrawing the amount. We want to, Lord, higher pay scale of the pension amount.
Now this
Lord,
judgment has come. So it-
No, judgment, Lord, we are entitled. The judgment says we are entitled. Lord, so kindly look to this. And that is why 11(4), Lord, has been enacted under Rule 11(4) of the Provident Fund rules.
That considering this, can we pass an order against an authority who is not an party to the?
This is not an against an authority. This is against NTPC. Lord, question is, Lord, they did not forward it. Lord, we are not claiming any order against the authority, PF authority. Lord, they are neither necessary party nor proper party, although I prayed for, but not necessary. Lord, it is a question.
Is it an integral part of the cause of action pleaded in the?
That's right, my Lord. It is an integral part of the cause of action, because I am entitled to have the salary, Lord, during the pendency of the suit, my Lord, of the writ petition. Lord, then we retired because of the closure of the school. And during that period, my Lord, my service was remaining. Therefore, my Lord, it is a subsequent fact, post-litem fact. Post-litem fact, my Lord, can also be taken into consideration for the purpose of granting a full relief to the party.
Then if you want to bring a subsequent event, then will you not amend your pleading?
Lord, it is not required, my Lord.
Will you not amend the pleading?
Lord, the Supreme Court judgment, your Lordship knows that 85 Supreme Court. Lord, they are
I'm giving you.
Yes.
For subsequent event, Justice K.T. Thomas, as his lordship then was, says that if you want to bring, you'll have to amend the pleading.
Lord, that is two judges bench. Lord, that is two judges.
Amend the pleading.
Lordship knows, my lord, that is two judges bench order. Principal order is AIR 1968 Supreme Court. Lordship knows that. This is three judges bench judgment. Therefore, court can take into consideration. Lord, in this case, it was taken into consideration.
Please, Mr. Banerjee, there lies a difference. The court says that the subsequent event shall be taken note of by the court in order to minimize the litigation. One principle. How that subsequent event shall be taken note of by the court is another procedural aspect, which has been dealt by the latter judgment of the Supreme Court, that how one should bring the subsequent event. Says that you must amend the pleading. If you, by way of a pleading, you should merely by saying in the open court that this thing has happened, or by bringing something on record without an amendment in the pleading or something, the court will not take into account. Then I'm talking about AIR 1994 Supreme Court against you, where originating from Calcutta High Court, where on an oral prayer, the orders were passed by our High Court. And the Supreme Court was very critical on that.
No, that's right, my lord. Exactly, my lord, on the basis of...
Bring a pleading. Unless you bring that, amend the pleading, how can it be done? Tell me.
They have shown, they of their own shown the reduction of the our.
Lord, this is a question.
আমাদের টাকার থেকে ডিডাকশন দেখাচ্ছে, এমপ্লয়িজ ডিডাকশন দেখাচ্ছে।
দাঁড়াও ওই কোশ্চেনটা। Lord, this is a... Lord, I know. Your lordship.
I think tell him the things are in a different way. Very difficult. The Banerjee faces difficulty, understand. It is really a difficult.
Undoubtedly.
I realize when I ask necessary party and proper party, himself says I am not.
Abandon precaution করেছে।
I am not seeking addition of registrar of
EPF.
Whatever.
EPF
Provident. He realized that.
But দাঁড়াও না রে ভাই।
He has an expertise in the civil law, and this is a pure civil question. Let him answer.
কি বলেছো তুমি? আরে 41-এ কি বলছে তোমার? আনসারটা কি দিতে হবে তো? Your lordship's query, my lord, is that even this is a subsequent event. Cognizance of subsequent event. Lord, after your lordship, your lordship judgment, my lord, K.T. Thomas judgment, your lordship is absolutely right. Yes. Lord, thereafter, all those judgment has been considered in 2010. Lord, in extenso, where application?
Judgment, don't worry.
Yes. That question would be, my lord.
Again, I say, the responsibility of the court to take note of the subsequent event is one. All the judgments are uniform. The court must take the subsequent event into account. If anything happened during the pendency, uniform. Nobody says that you cannot. But this second limb is the procedural one. How those subsequent events have to be taken? Is it orally it is brought to the notice of the court, or by simply filing an application it has to be brought, or by amending the main petitions and then brought to the notice of the court?
Lord, my respectful submission would be before your lordship. Misquotation of section or non-quotation of section does not matter. It may be treated, Lord, it may be treated.
Judgment of the Supreme Court, it says it matters.
Lord, this application can be treated as an application for taking cognizance of post-light impact, because we have said that. Lord, your Lordship knows the judgment of Krishna Ayar, my Lord. Court is not vexed with the technical tortures.
J.J. Ram's case from
Joy Joy Ram case, 69 Supreme Court, 1267. Lordship, handmaid of justice.
not to be
Lordship. And Lord, Lord, I leave it to your Lordship if your Lordship say that. But these can be treated
He kindly peruse
as
the
an
prayer
application.
made, the writ petition and the prayer made by you in can 14. Can it assimilate?
May I come to the writ petition prayer?
Writ petition prayer which has been allowed by the trial court and the prayer as made by you.
Lordship. Lord, writ petition prayer, my Lord. Writ petition prayer, page 36, my Lord, of the paper book.
Yes, sir.
Lord, prayer A,
Prayer A has been denied.
denied.
Declaration
Denied. Local managing committee constituted by,
2 has been allowed.
right.
T1 and 2, whether you come within that purview.
Three.
Sorry,
2 and 3. 2 and 3.
Lord, 2 and 3. C, 2 and 3.
Actually, come to 3. Read 3 and then you pray your prayer.
3. The respondent NTPC authority to disburse and pay through the administrator to be appointed in the school to the petitioners their arrears, salary and admissible allowances, granting increments along with interest as reasonable rate. Of interest after extending the benefit of ROPA rules and ROPA rules 2009 from the respective date of their effect, to pay the petitioner their current salary, the admissible allowances.
3. 3 part.
3 part.
Now tell me whether this prayer is tallying. Are you not enlarging the scope of the appeal?
Now, my Lord, a question would be, my Lord, whether while deciding this question, Lord, it is pertinent to, Lord, that pensionary benefits, my Lord, is out of that service benefit. It is a service benefit, continuing cause of action. Pensionary benefits, my Lord, is a continuing cause of action. And therefore, my Lord, my respectful submission is that it includes that also, which is a subsequent fact, because they got an order for the purpose of stopping the school. As a result, we have been forcefully, Lord, dismissed from service.
Because they were permitted for the simple reason that the first prayer for declaration that the agreement is void was negated by the trial court. So their discretion or the power remains under the agreement. If they decided to close down, there was no fetter, nor there was any interim order passed that you cannot close down the school. So the court can definitely pass certain order, taking into account the exigencies. There were only 5 students in the school at a relevant point of time, whereas there were 15, 20 numbers of the teacher.
Yes, Lord, therefore, Lord, the question would be, Lord, question would be.
For teacher, there was 1 student.
Yes.
That is what is.
Lord, this is my respectful submission. This would be the consequential relief. Consequential relief. Yes, unless, Lord, unless I am being allowed to pay salary under the, Lord, affiliated school authority by the Secondary Education Act, Lord, question of payment of pension and other benefit would not arise.
Yes,
Lord, we shall have to file it. They may be permitted because we have submitted that. If your lordship kindly look to this document, my lord, they have received it. This is without prejudice. Your lordship is not deciding any rights. Page 40. Lordship kindly come to page 40. And 41, they are to sign it. We file it. They are to forward it. But that will be, my lord, subject to the result of the appeal. If I win in the appeal, Lord, I will get the relief.
Rule requires that they should.
And rule, my lord, permits that.
Rule requires that.
Rule requires that. Otherwise, I am not entitled, Lord, to have the.
on this. The reaction on this.
Regarding his prayer,
The joint option form or something like that. Is this?
Adding regional Provident Fund Authority as a party respondent.
my lord, possibly your lordships can say that it will be open to the Provident Fund authorities to process their
How?
Says is that
Unless joint option is.
who will sign it?
not signed by the employer, they will not process the application.
Because since there is the peculiar situation is that there is no employer as on date. Therefore, considering the orders earlier,
This is according to you that the larger question is still remains that who is an employer.
no, NTPC is not the employer. There is a judgment already holding the field. Therefore, my lord, since that is the position and the school has closed, there is no local managing committee either. Therefore, taking note of this fact, it is the Provident Fund Authority will be entirely at liberty to process their application.
To process their application for pension on the basis of higher wages.
Higher scale.
To pension as admissible in law.
Higher scale.
Otherwise, my lord, this will be an issue.
Higher wages.
Otherwise, this will be an issue, my lord, totally outside the scope of the appeal.
Unless, my lord, under section 11, subsection 4, Lord, counter signature.
Whether they are the employer and the
Lord, my respectful submission.
Limited is not an employer.
Lord, yes.
Happened.
Lord, I will answer to that query, my lord, subject to my lord's acceptance. Lord, my submission is.
By his statement, where is, if the judgment, the judicial pronouncement is that the NTPC is not an employer, then tell me how can we compel the NTPC to sign as an employer?
Yes. Lord, my submission. Lord, my submission is, Lordship knows, Lord, when a writ appeal is filed, Lord, 1981 Supreme Court, Lord, second volume part, whether Order 43 Rule 1 applies mutandis in latest patent appeal. Lord, it is a very big judgment. Lord, at least, my lord, 43 pages judgment, my lord. There the lordship says, yes, the civil procedure code applies to that extent. Now, my lord, my respectful submission, Order 41, Rule 5, they ought to have obtained a stay order, prima facie case in my favor because of the judgment delivered by the writ court. Writ court in my favor. Therefore, I am entitled to have, on the basis of that, interim order has been passed.
Asking you a very basic question. You have sought for a direction upon them to sign on a joint option, which is relatable to an employee and an employer, which can only be signed by the employee and the employer. They say that so far as the NTPC Limited is concerned, it has been held in a judicial decision that NTPC is not an employer.
It's opinion, it was opinion.
Now the question is, they say that the school is closed. It is the local committee of the managing committee who was regarded as an employer is no longer there. Then what to do? Compel NTPC to sign as an employer when they are already blessed with the judgments holding that you are not an employer?
Lord, it has. Lord, my answer to the question is, my Lord, if he is not an employer, after the closure, Lord, the NTPC was directed to pay the amount to us, and they deducted the amount. NTPC deducted the amount in terms of the interim order without prejudice to the rights and contentions of the parties. We are not questioning for decision on the rights of the parties. We are questioning that the procedural aspect. These are the procedural aspects. You are to, because when you have collected, when you have paid the Provident Fund authority, that the 50% amount as per law, when you have paid, and then you have deducted that amount, deposited to the Provident Fund authorities in terms of the interim order, without prejudice to the rights and contentions. And this order is binding on you. And now you cannot say, I have no right to say that. What I am saying this, that you sign it. We may be, and forward it to the authority, PF authority. Let it be kept on record. Your Lordship, after the decision, Lord, it will be taken up. It will be taken into consideration. I am not claiming here and now the enhanced amount be paid to me. I am not saying that, my Lord. I am saying option form. Because, my Lord, your Lordship sees that NTPC, my Lord, published an advertisement. Advertisement, your Lordship knows.
Argued you were not there in the picture. And ultimately it was held nothing. No.
Employees amount তুমি ডিডাকশন করছো তাহলে এমপ্লয়ার অ্যামাউন্ট করবে না কারণ এমপ্লয়িজ কন্ট্রিবিউশন তাহলে ডিডাকশন করছো এমপ্লয়িজ কন্ট্রিবিউশন
Lord, my Lord, my deduction, employees deduction you have made in terms of the interim order. NTPC deducted. Lord, that is the document we have submitted. And now employer, you are not to contribute. Lord, fairness in action on the part of the NTPC.
If they do not comply the interim order, you come for the content. And once they comply, say that you have already complied the order, so any action which is taken under the gist of contempt and in terms of the order, does it create any rights into another person?
It is statutory obligation. Lord, it is an obligation, statutory. Lord, my respectful submission, it is a statutory obligation.
You are putting them in both the ways to suffer. If they do not comply, you will come that despite the interim order, contempt yourself.
Lordship, kindly look to
comply. Then you say you have already complied.
No, they have deducted. Lord, they have deducted, then they will not deposit.
Or interim order can be varied at the subsequent stage. It has to be made absolute to operate till the disposal. It can be varied at subsequent stage.
But my Lord, my respectful submission, parties accepted, and then parties, my Lord, deducted the amount. Employees deduction.
Everything without this.
Employees deduction, my Lord.
Expanding the scope of the appeal, which is a limited one.
Lord,
everything has
this is not expanding, my Lord, the scope of the appeal.
The mess has been created.
Lord, this is not expanding the relief claimed in the writ petition.
Anyhow, yes. What is the joint option form?
Annexed in the application.
Lord, yes, my Lord, that is page 37.
Submitted. Whether they will grant or they will not grant is a different.
The joint option form, first of all, NTPC can't give. It is to be done with the school authority, number one. Number two, school
No.
But this
No.
joint option form is only for a higher amount to be contributed.
Hey, 11.4 কি বলছে?
Higher.
Or the same amount, there is no difficulty.
No requirement of joint option.
Oh, then.
If it is within the sitting, then there is no question of joint option.
No, your Lordship, kindly look to 11.4.
The Supreme Court has said no higher amount.
2023.
No, that was explained by the Honorable Supreme Court. So mean that in 6 months time period, whoever wants to give option, they can give.
Lord, this is the Supreme Court judgment, my lord.
They have not given option.
No, this is Justice Ananda Bose, authored by Justice Ananda Bose.
No. Supreme Court did not say, my lord, that 11.4 will not be complied with. 11.4, my lord, with regard to.
Authored by Justice Bose, you say no. It is authored by Justice Bose.
Your lordship, look into that.
We are looking into it.
Yes,
Bose.
yes, lordship,
Say no.
lordship.
Probably from paragraph 46 onwards, your lordship.
Page 46. Page 46.
Page 46. Page 46.
Page 46. Page 46.
Can number
Yeah.
15 of 2025.
Yes.
Page 46. Para 44.
Lord, paragraph 44, my lord. Page 46,
We are reading it.
lordship. কোর্টটা কবে এসেছে গো 11 কোর্টটা কবে অ্যামেন্ডেড হয়েছে কবে 6 দাঁড়াও না রে ভাই এই তো 3-এতে বলেছে 3 এই তো 3-এতে রে ভাই 1 September 2000 will be guided by the 11.4 page 47 Roman 3 and Roman 4 my lord I'm entitled
Did you exercise the option within 4 months from November 4, 2022?
Look, they have extended up to 31st of March subsequently to
I am asking you that Supreme Court has said that 4 months from the date, then November 4, 2022. So this extension is December, January and February. And March.
now Lord, they have extended it.
March, if we go by anniversary to anniversary.
Yes.
2023. Did you exercise that option before 2023?
Not exceeding 6 months. তারপর কি হলো?
No, that was very key. There was a challenge. It was declared to be ultra-virus by various high courts. Supreme Court has set aside the order and says that since the time period has elapsed, you have given a cutoff date. Certain persons who have already exercised that option, they will continue under this. And those who could not exercise the option, and because of that particular judgment declaring this provision to be ultra-virus, we give them a further chance to exercise option, which is with a cutoff date of 4 months. Did you exercise that option?
Yeah, that is why we exercise option. They did not.
That time limit.
EPFO extended the contract.
Lord, Provident Fund Authority extended the time 31st of January 2025.
If the Supreme Court judgment is given an option, that's enough.
Lord, that is they are entitled, my Lord, on the basis of that. I shall come back with that notification.
This provision actually, that your lordship may kindly take the page 26, notwithstanding. Right and right thing. Of my application.
ওদের নোটিফিকেশনটা আছে যে 31 তারিখ পর্যন্ত দিয়েছে। হ্যাঁ, নোটিফিকেশনটা কোথায় দেখো না, দাও না আমাকে।
The class of the employees who are entitled to this fund. Why you are citing this?
That joint option form. 26(6).
Yes.
I did not get that. But however, I say the greatest of respect that I keep Perus.
26(6).
Yes.
On the joint requested writing. No, I'm talking about this judgment has said only 4 months.
That was extended by Provident Fund authorities for some period of time.
So have they exercised the option?
No.
Yes, we have exercised the option, my lord. We have exercised the option. Lordship, kindly come to page, my lord.
To show that they had deposited in excess of their ceiling.
That's what I'm asking.
On their actual salary, they have contributed.
They have to say that under the proviso to paragraph 11(3), they have exercised an option.
Yes, we have said that. Yes. The paragraph, my lord, we have said. Kindly come to paragraph.
The document of exercising the option. There must be a letter. It should be done in writing. Show us.
Page 33, page 33. My lord, page 33, my lord. 8 of the page, assistant committee.
This is check number. Submission of joint option as per judgment dated 4/11/2022 in this number.
Okay. Do not find any option is exercised.
Provident Fund Authority, এই তো Provident Fund Authority.
No, it is there at page 33.
33 and
1999.
yes.
Joint deduction for deducting PF তখন 5,000 ছিল, সিলিংটা 5,000 ছিল।
Yes, he has exercised the joint option in 1999.
Yes, my lord. Page 33.
Are you there in the secretary?
Yes. We are there. Number 7.
Number 7, my lord.
Then Omil Kumar Mukherjee 13. 7, 13. All of them. 40. Page 11 Singh.
14. না গো, একটাই আছে। দিয়ে দিলাম তো আমি।
জাজমেন্টটা কত দাও?
এইটাকে দেখি।
ওটা না, ওটা জাজমেন্টটা কত দাও? 1 মিনিট থেকে 23 টাকা দাও।
Where is the applicant number 1?
Applicant number 1 is that page at serial number 40.
Where is the name? I do not find.
Item number 40, serial number 40.
Serial number
40.
Yes, 34.
Then 36, 40.
ওটা তুমি দেখো 36 না
36 আছে কিনা একটা সরকার।
এই 36 40 Tej Narayan Melod 40
2 আছে
and then 2 Melod
730
serial number 2713
then 36 40
2713 then 36 then 40 they are the petitioners, Melod.
Yes, Mr. So they have exercised this option in way back in 1999.
But unilateral exercise option is not sufficient as per this.
What? No, no, managing committee of the school has also signed it. At the bottom, page 34.
It's 34 bottom.
It's a joint option.
School
It's a joint option. The tenet of the letter says joint option.
That is why, my lord, we are getting pension also. Those who have been, my lord, already retired.
It's a joint option that you can't.
Joint declaration.
You have used the word joint option.
Joint option, lordship, joint option.
The PF authority can proceed on the basis of this without involving us.
Oh,
On the basis
this
of
is their proceeding, my lord, they are paying, but we are.
authority can proceed on the basis of this. Page 33.
Does it require a further one?
No, further to no, it's not necessary either.
Lord, ceiling at that time it was a ceiling. Now, my lord, it is 6,500 to above 15,000. Now our salary is 15,000 at the time of retirement, and that is why we are entitled to have the joint option, file joint option for higher pension under Rule 11 sub Rule 4.
Your lordship kindly take up 42 and 43 paragraphs. They are covered by this. They will get this. 42 and 43.
42 or 43 of what?
Of this judgment, Supreme Court judgment. This 2020.
No, I have seen that. The paragraph
42.
42 or paragraph 40?
Para 43.
Paragraph 43, yes.
The other condition for enhanced coverage is related to the date within which such option is to be exercised by member. The 42. The dual option as is contemplated in paragraph 11.4 of the pension scheme post 2014 amendment has to be merged into one. In the event the employer and employee jointly opt for coverage beyond the salary limit of 15,000, it was 5,000 initially.
Without giving
an earlier option under the unamended clause 11.3 of the pension scheme, they would not be automatically excluded from their right to exercise option under paragraph 11.4 of the scheme post amendment.
They are already treated as higher options.
They are submit করেছে কবে 99. They are
if the PF has treated
page 33
prior to 2000.
Yes. Therefore, this prior to this amendment, unamended provision they had exercised it, and then it says they would not be automatically excluded from their right to exercise option.
Right to exercise the option, but the option has not been exercised.
Earlier 99 they have exercised option. Page 33 is that is the exercise of option. Exercise of the option to deduct more.
Not holding that no option was required to exercise as per the proviso to paragraph 11.3 as it stood prior to
Not 43. Other condition for enhanced coverage relates to the date within which such phase option is to be exercised. But I am coming within the purview of 43. That is why, my lord, 11 sub-rule 4 has been enacted by Amendment 19, 2014, Amendment Act.
You know, kindly also read the last sentence in paragraph 41. Paragraph 41, last sentence. Those who had exercised this option prior to 14 amendment.
Yes,
as
it is after the 14 amendment.
1999. They did not exercise anything.
No, we exercised.
No, that was free.
That is free.
The 99 also exercise.
But that has to be further exercise.
No. That exercise 43. Lord, I am coming.
Please, I'm sorry for my impertinence or my non-understanding of the. Consider it. Let me read the English language which is used. The dual option, as is contemplated in paragraph 11.4 of the pension scheme. I am reading paragraph 49. Post 2014 amendment has to be merged into one. Dual option merged one. in the event the employer and employee jointly opt for coverage beyond the salary limit of 15,000 without giving an earlier option under the unamended 11.3 of the pension scheme, means if they have not given an earlier option.
But here it was earlier given.
It was a case where it was earlier given. Then
Then.
they would not be automatically excluded
Who?
from their right to exercise option. So
They
it
means
says
who did not.
now they can exercise option.
So they means they who did not.
Did not, correct.
Now here they did.
Then 43. The other conditions for enhanced coverage relates to a date within which such fresh option, that means there was already an option and a fresh option is to be exercised.
No, minute, that
So
is.
it's to be exercised by a member which is stipulated to be within a period of 6 months from.
It is not further option, it's a fresh option.
No, it's
Those
a
who had
fresh,
not.
it's a fresh.
No, fresh means a fresh,
It
but
would
not
be
a further.
legitimate to proceed on the basis that several members did not exercise this option earlier because of the stand of the authority that the option under proviso.
It all relates not to those who had not
exercised within a specified date, which stand was negated in R.C. Gupta's case. We are of the view that the time limit for coverage beyond the earlier ceiling limit should be extended by a further period of 4 months.
But entire paragraph 43 relates to those who had not exercised option. Entire paragraph 43. The second sentence, it will be, whenever the ceiling enhanced, 5,000 to 7,500 like that. It would be, second sentence, paragraph 43, it would be legitimate to proceed on the basis that several members did not exercise such option, therefore this. Those who had earlier did.
যেই টাকাটা টাকা জমা পড়েছে সেটার উপরে পেনশন ক্যালকুলেশন হবে তো।
The pension will be calculated on the basis of the amount actually deposited. How can it be enhanced afterwards? Certain money was deposited already.
So for enhanced
pension will be calculated on the basis of that.
After a phase,
there cannot be any scope now to make more deposit.
Lord, if it is not filed, then my lord, enhanced coverage, we are not entitled.
Paragraph 41, what you say has to be read.
Yes,
Paragraph 41 is throwing a light on that.
That is the second condition. In relation to the second condition.
No. So far as
the first condition.
That is what we have expressed our views earlier in this document.
As regard the legality of having such a problem.
No question.
In relation to second condition.
Yes, we are.
Our opinion is that the eligibility for enhancement cannot be restricted to those employees only who have exercised the option to remain in the scheme once their salary went beyond the capping of 6,500 per month. As we have already discussed, in case of R.C. Gupta, it has been specifically held that there was no cutoff date in proviso to paragraph 11.3 as it stood before 2014 amendment. In our opinion, the interpretation given to proviso to sentences prior to 2014 amendment does not require any consideration. We agree with the reasoning of the two judgments of this court on this point as expressed in the judgment. As there was no cutoff date to be contemplated prior to 2014 amendment, limiting the entitlement of enhanced pension coverage to those employees only who had already exercised an option under clause 11.3 of the unamended scheme would be contrary to the ratio or the judgment of this court held in R.C. Gupta. We are not holding that no option was required to be exercised as per the proviso as it stood as held. So it says that once you exercise, that's enough. That's enough.
That's enough.
This is no, Mr. Paragraph 41 is clear. Once you have exercised an option, matter ends. It is up to the PO authority. They have to give you the
enhanced pension. Enhanced.
They have to give you
enhanced pension.
They have to give you. They will give you. You are not required to give any joint option.
No, joint option.
My application page 56 for a second.
Yes.
Page 56.
Page 56 of what?
That is again the SMS. What?
For employers to forward application on higher wages to EPFO. Your application for pension on higher wages has not been from our employers. Applications not forwarded by the employer by 31/1/2025 shall be rejected.
You have excised the option
And Miller, can you see also that I was trying to
unamended.
kindly Miller one more. One more.
What is the date of the scheme which was amended in 2014?
1995, amended in 2014.
So in 1999, that scheme was there.
Absolutely. And when I have submitted a joint option form at page 41, that joint option form was submitted on Miller 25/6/2023.
দাঁড়াও না রে ভাই, ঠিক আছে সাইড সব entitled.
দুবার করে দিতে হবে না হয়তো দুবার করে
দিতে হবে না, ইন্টারপ্রেট করে দিক।
দিয়ে দিন রাইট নেই আমরা অপশন দিতেও দেবে না চাইলে দুবার দেওয়া যাবে না সিস্টেমে সিস্টেম আমাকে বাউন্স করবে আমি কিরকম দেবে না
এরা তো রিট পিটিশন, এরা তো রিট পিটিশন।
No, no. 14, let us do one thing. So we wanted to take a decision that this is not required in your paragraph 41 of the judgment of the Supreme Court. But still, the order has to be passed before the authority, because the authority may sometimes come and say that in my absence, the order has been passed that will be. We are not adding because they are neither necessary nor not. But we can treat them as an intervener and we are directing the service of the copy upon them.
No, so far Mr. Banerjee's clients are concerned, they are রিট petitioners.
They are রিট petitioners.
They are রিট petitioners.
রিপিটিশন ছিল।
For Mr. Bhattacharya's clients are concerned, they are the interveners. 415.
May I?
They are the added one.
Added.
You are added as a party
And 15.
in the repeat.
Supporting you.
And
Right.
15. Same stand.
Same stand.
The relief claim with the.
ঠিক আছে, ভালো করে বসো না।
Can 14 and 15.
Instrumental to it or who I do this?
No, returnable, my lord, return it 1 week. And I shall file affidavit of service. Yes. Lordship.
15 is also 7.
Then we have passed come back.
14 and 15.
Both. Or it will consume a lot of time because just to assimilate what has happened, I think much water was flown, which should have been stopped by putting a dam or something.
But all of us, Lord, know, my Lord, that your Lordship goes to the Lord deep, to deepest, Lord, not on, Lord, so that justice can be delivered, my Lord, fruitfully.
Call the next.
Lordship, Lord, I am deeply.
Let it retain its position. Your lordships have heard that matter, this matter.
Your Lordship, I beg to appear on behalf of the respondent number 1.
Why? What is this?
On maintainability of a writ petition against a private school.
Your Lordship,
They have not, was not there. Short notes of arguments have been filed.
Yes, Your Lordship. I beg to appear on behalf of the respondent number 1. We have already filed the.
Why you have inculcated this habit of using the word big?
I'm extremely sorry. I beg your pardon, Your Lordship.
You have a right to represent your clients, and why you take?
Actually, for the very first time, I'm representing my learned senior counsel before this honorable bench. So,
It's, let this matter be listed. This এটা ফাইলটা কি আছে দেখো একবার পাঠিয়ে দিও এটা পাঠাও দেখার কথা দেখার কথা ওনার কাছেই পাঠাবে আমার কাছে দেবে না আসুক তারপর তো আসবে আসার পর ওনাকে Just call the next.
My appeal will from an order of termination from service. So appearing as a fixed matter, there was an interim order which expired 31st of the last month.
Can it be finished by tomorrow?
If we
Both of you.
For me, it will take 45 minutes. For me, it would take 45 minutes.
I can take maximum 20 minutes.
So it can be finished.
Can you ensure that you will complete the argument because this bench is
Yes.
tomorrow?
Why she?
We do not want that this matter to go up.
That is why.
Otherwise, again problem.
That would be might be a
That's the problem, difficulty.
That might
May not.
That's why we are asking.
Because there are so many documents, inquiry report, so many documents.
Before the regular picture.
Then after 2 weeks.
So kindly extend the interim order today.
What is the interim order?
But the interim order was there.
Not to fill up, not to fill up the post.
That will remain.
Not to fill up the post. Two posts, not to fill up.
After 2 weeks. Interim order granted earlier shall continue for the further দিয়ে দাও দুটো করে।
My lord, 8 I appear for the respondent, my lord. The appeal is against an order, my lord, against a judgment and decree passed in a partition suit, my lord, against preliminary decree. My lord, there was some
Already passed.
no final degree. There is the order yet to be passed, my lord. My lord, the fact remains, my lord, there was for calculation of shares, there was some mistakes, my lord. My lord, we will be conceding to the prayer of the appellant, my lord. My lord, and we have handed over the calculation sheet, my lord, so far as the shares are concerned, my lord.
Hand over.
My lord, এটা দাও আরে এর মধ্যে ছিল তো উফ বাবা
Take out the consent and give it.
Fine.
Yes.
My lord, I am for the appellant. Mr. Shomik Ganguly is appearing in this matter, my lord.
Just the
My lord,
respondents are coming forward and
it
saying
is
that whatever you have prayed for.
no objection brief, my
accept.
lord.
My lord, the shares, my lord, page 3, running page 3 of that bunch, my lord, we have
What has been held by the court?
my lord, so far as the one of the brothers, my lord, he was a bachelor. He died, my lord. The
Or plaintiff or a defendant, tell us.
but we are for the respondents, my lord. Plaintiff number 2 respondent. I am appearing for the plaintiff number 2 respondent. Plaintiff number years of the Shivani.
Yes.
Well, he has filed the appeal, my lord. Shivani is the for the plaintiff number 2 appellant. And I am for the plaintiff number 1, disease plaintiff numbers 1 years, that is respondent number 1A and 1B. Well, first,
Tell me, you are Shukanya Dotto and Solil Dotto.
Sukarna Datta and Sholil Datta.
Give me the name. Don't say plaintiff. Yeah.
Right, page
Shukanya Dotto and Solil Dotto. Then
page 3, my lord, we have stated the shares, my lord.
I am looking at page 3. That's why I'm.
My lord, my lord. Plaintiff
then-
number 2 is the appellant and plaintiff number.
Then Anita is the substituted ASN representative of the defendant number 1.
Anita is the substituted defendant number 1A of the, and here has been, he has,
whatever.
with this appeal, my lord, he is respondent number 3. And there, we have given the respondents and the defendant numbers chronologically, my lord.
So according to the Shivani, I do not know whether male or a female.
Female. Shivani is a female.
Your wife?
Shivani has 645th share.
645th share, madam. And the so far as Sukarna, Sholil, Anita, Abhishek, it's really 1/18th.
And how much has been declared by the court according to plaintiff's share?
But so far as the plaintiff's share, one of the defendants died. He died as a bachelor. So, my lord, his share, my lord, will go to the male defendant, my lord. His share will go to the living brothers and sisters. What has been made, my lord, it has been divided, that his share has been divided amongst all the parties. That should not be the case, my lord. And the learned trial judge, my lord, made a mistake on that aspect.
Your adversary is able to accept this.
Who were the brother and sister?
Well, the persons who is getting 6 by 4/5 share, they are the living brothers and sisters. And the so far said the 1/8.
So Shivani was declared how much share? Less than 6 by 45?
Less than 6 by
45. No, এখানে দিয়েছে তো 116
So
মানে
no
130, 132. According to the decree passed by the learned trial court, plaintiff number 1A and 1B, they will get
Hello,
only
it's
160.
my lord, may I? Hello, it's my appeal. I intend, my lord, not to proceed with the appeal.
What is saying, you know?
Yes, my lord.
You know?
ব্যাপারটা কি হলো?
তাই তো, আপনার instruction তাই তো? He is present over.
যেহেতু সে একটা ডিফাইন হয়ে গেল তবে না
না যদি অ্যাপেলেট না প্রসিড করতে হয় আমরা কি করবো?
যেই যদি করে উঠতে হবে।
এই
She
অ্যাপিলটা
has got more or less.
got less.
The property, she says, the property in question, the shares which were allotted, their part, not their part, the joint part, most of it has been sold by this respondents.
That is, I am not joining issue in that. So far as the
Yeah. You are the advocate in the court, madam?
No, Preeti.
Under the heading to be mentioned.
Please tell her address with the date.
Yes.
There is the counsel for the appellant submits.
আগে সই করিয়ে নেবেন।
Yes.
Well, there was a direction upon the state to bring the report. This matter relates to lordship
Lord,
that giving
this is
the-
similar to 5 and 6 because the regular bench has heard it and the interim order is till end of February, my lord.
Let him come. Adjourn for 2 weeks. Interim order is up to February. For February, he will come.
আস্তে
21 তারিখ 24 চলে আসবে।
সপ্তাহে পেয়ে যাচ্ছে।
Yes. The report has to be filed by the state on that direction.
Criminal matter.
Your Lordship, Mr. Anil Kumar Gupta is there on behalf of respondent. Lordship, I'm praying for not this week, he's out of station. He has gone in Kumbh, Your Lordship. He's out of station, Your Lordship. Not this week, Your Lordship, I'm praying.
To come.
Yes, Your Lordship.
Alone.
No, with family, with his family.
Maybe one member of the family here. Yes. Not entire family.
That I have no knowledge, Your Lordship. Not this week, Your Lordship.
Sixteen, my lord, we are filing applications for addition of party. We are the requiring body, WBSCTCL authorities.
My lord, I am for the responding.
মুনমুন 15 থেকে 17।
My lordship, I beg for not today. I am here for instruction of Supratim Dhar.
সুপ্রতিম রয়
Probably busy in other.
সুপ্রতিম ধর
এটা 15 থেকে 28 তোমার কোনটা?
not today. ঠিক আছে, ফেরত দাও। আমি WBCT
হ্যাঁ
থার্সডে মানে 6 তারিখ টিচার কাছে অ্যাসাইন করে দিয়েছি ওটা না এখনো যায়নি